They are, I'll call the docket since they're. All right, everyone. Happy Thursday. Today should be a great day for everyone because tomorrow's Friday. So I'm going to call the docket. Let me know that you are here. Please stand if possible. Roger Saucedo.
Present.
Thank you. In custody, we have Robert Roth, Eric Gonzalez, Guzman, Lopez, Allen, Ibanez, Dominique Brinkley, Pedro Alvarez. Thank you. In custody, we have Torres, Devin Magallanes, and I pronounce the double L's correctly and everything. Thomas Toledo, Jess Mafnes,
Here.
okay. Christopher Anthony. In custody, we have Cabot, Luciel Avila.
Right here, ma'am.
Thank you. Ruben Gonzalez. Adam Rafti.
Here you are.
Thank you. In custody, we have Rodriguez Ortiz, Romero, Mario Miranda.
Present, Your Honor.
Thank you. In custody, we have Neuenfeld, Solis, Scantlin, Robert Andrade,
Here you
Demetric Jackson.
Good.
In custody, we have Gibbons, Jose Torres.
Here you are.
Thank you. Custody, we have Roth, Devin Magallanes. Carlo Martinez Landaverti in custody. Bolden, custody, Hernandez, Jones, Gomez, Ortiz, Murado, Mesa, Gilliland. Custody, Tony Segura. Ibarra Parker. Custody, Paul Duncan. Burnham. Thomas Toledo. Custody, Ramirez, Davis, Martinez, Maldonado, Mario Pineda.
Your Honor, he's the president on Zoom.
Okay, all right, thank you. Why is he on Zoom?
I believe he was granted permission. He lives out of in Houston, so he's been zooming into the.
Okay.
hearings.
All right, thank you. I'll have to check my my docket because I write that in docket. It's not on the docket sheet though. Gracie Segunda.
Your Honor, that's same
And-
with the co-defense.
All right, thank you. Robert Castillo,
Here.
custody Morado. Eduardo. All right, Tony Morado. Eduardo Guarda,
Present, Your Honor.
Ortiz custody. And Magallanes and Ramirez should be at 11. Sean McHaslick custody, Katrina Mendoza and Jose Ruiz custody. Is there anyone who came in later? Your name was not called. Yes, what is your name? Gloria Orozco. Do you know who your attorney is? All right, just give us a moment. Anyone else who came in later, your name was not called. All right, so everyone, what we're going to do is we are actually going to do closing arguments this morning. So after closing arguments, then we'll take up the other matters that are on the docket. So I'm going to need you all to clear the jury box. And do y'all know, is defense counsel in the side doors? Can you check for me, please?
Sure, Judge.
Thank you. Oh, yeah, no, I'm telling you, I'm going to read it exactly as it is. This is a long charge.
Yeah, we're saying,
Yeah.
we're here already. but-
Yes. No problem.
How long are they?
And I'm going to read it exactly as it is. Okay. All right, we're just waiting for defense counsel to come in. Thank you so much.
Welcome, Judge.
Morning, Your Honor.
Good morning. Hi.
Somos tacaños, we always have that same problem.
Yeah, approach.
Yes.
Don't see a. Note indicating.
No, you know what's so funny? I went to go speak at a
Okay.
school for
Okay.
children and they gave me flowers. But as somebody said, the lilies are very aggressive.
Yeah, we're about to be closed.
So, all right. All right, we're going to go on the record. Court is calling.
He was back.
There he is.
5'8", dark hair, dark eyes, last name ends in easy.
5, 7, 6. Let's not give it too much.
All right. And Deputy Laura? I'm concerned about my place in my mom's affection because guess what she tells me? She's like, is Jason going to be here today? I'm like, does it matter if Jason's going to be here today?
What about Daniel?
What about Daniel? What about Ruben?
All the characters in the show.
What about Lewis?
All the characters in this little soap opera she watches.
Yeah. All right, everyone, if you'll please have your seat. And if you can line the jurors up for me. Court is calling 2022 CR. Attorneys, please take your seats. Court is calling 2022 CR 7550A, State of Texas versus Courtney Pride. Can I have parties announced for the record for the state?
Daniel Escobar and Ruben Herrera for the state.
Defense?
Louis Martinez for Courtney Pride.
All right, and are you Miss Pride?
Yes, Your Honor.
All right. So state and defense, have you had a chance to review the charge of the court?
Yes, Your Honor.
Judge, we reviewed it that after court yesterday. We've got no objections.
All right, state, any objections to the charge?
No, Your Honor.
All right, thank you. They're lining the jurors up. And my understanding, both sides is requesting 15 minutes.
Yes, Judge.
I'm requesting 10, Judge.
Okay. Any time announcements?
Judge, at the 5-minute mark, if we can get an announcement. So with 10 minutes remaining.
Judge, if I could get notified at 2 minutes remaining.
Okay. And so Ruben, you want to know when you've used 5 minutes?
Yes, Your Honor.
Okay. Sure. And everyone, please make sure your phone is on silent or vibrate. There's nothing worse than people giving closing arguments than a phone call interrupts their flow. All right, we're ready.
All right, for the jury.
All right, everyone, please be seated. And as you can see, the courtroom has more people in it than it normally does. So this is a part of my morning docket. So they are not here for this case. They have absolutely nothing to do with this case. If you see someone coming through that door, it's because they haven't read the sign on the door that says jury trial in session, do not use this door. If you see people coming from this door, that's usually staff and they're just giving me paperwork to sign. Again, it has absolutely nothing to do with this case. I'm going to read to you the charge of the court. You don't have to memorize it. A copy will be given to you once you begin your deliberations, okay? Charge of the court. Members of the jury, the defendant, Courtney Kiara Pride, stands charged by indictment with the offense of assault against a security officer alleged to have been committed on or about the 5th day of December 2021 in Bexar County, Texas. To this offense, the defendant has pleaded not guilty. 1, our law provides that a person commits an offense if the person intentionally, knowingly, or recklessly causes bodily injury to a person the actor knows is a security officer while the officer is performing a duty as a security officer. 2, bodily injury means physical pain, illness, or any impairment of physical condition. Security officer includes the following: a commissioned security officer, defined as a person who is employed by a security services contractor or the security department of a private business and is employed to perform the duties of a security guard, security watchman, or security patrolman. A non-commissioned security officer registered under Section 1702.221 of the Texas Occupations Code. Section 1702.221 of the Texas Occupation Code provides that A, to perform any activity regulated by this chapter, the individual must 1, obtain the proper individual license under Section B, and 2, be employed by a company license holder. B, an individual must obtain the appropriate individual license in accordance with the requirements of this chapter and related administrative rules if the individual, 1, is employed as A, an alarm instructor, B, an alarm systems installer, C, an alarm systems monitor, D, an electric access control device installer, E, is a level 3 classroom or firearm instructor, F, a locksmith, G, a non-commissioned security officer, H, a level 4 personal protection instructor, I, a private investigator, or J, an individual whose duties include performing another activity for which an individual license is required under Section E, or 2, is an owner who owns at least a 51% interest in a company license holder. 3, a person acts intentionally or with intent with respect to the result of her conduct when it is her conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of her conduct when she is aware that her conduct is reasonably certain to cause the result. A person acts knowingly or with knowledge with respect to the circumstances surrounding her conduct when she is aware that the circumstances exist. A person acts recklessly or is reckless with respect to the result of her conduct when she is aware of, but consciously disregards a substantial and unjustifiable risk that the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. 4, you are instructed that a person is presumed to have known the person assaulted was a security officer if the person assaulted was wearing a distinctive uniform or badge indicating the person's status as a security officer. Therefore, if the complainant was wearing a distinctive uniform or badge indicating his status as a security officer, the defendant is presumed to have known that such complainant was a security officer. You are instructed that A, the facts giving rise to the presumption must be proven beyond a reasonable doubt. B, if such facts are proven beyond a reasonable doubt, you may find that the element of the offense sought to be presumed exists, but you are not bound to so find. C, even though you may find the existence of such element, the state must prove beyond a reasonable doubt each of the other elements of the offense charge. And D, if you have a reasonable doubt as to the existence of a fact or facts giving rise to the presumption fails and you shall not consider the presumption for any purpose. Therefore, if you believe from the evidence beyond a reasonable doubt that Adam Moreno, at the time of the assault, if any, was wearing a distinctive uniform or badge indicating his status as a security officer, it is presumed, and you may find that Courtney Kiera Pride knew that Adam Moreno was a security officer. However, you are not bound to so find, and even if you do, the state must still prove beyond a reasonable doubt each and all of this and the other elements of the offense of assault against a security officer as alleged in the indictment. And if you have a reasonable doubt that, or as to whether Adam Moreno was wearing a distinctive uniform or badge indicating his status as a security officer, the presumption that Courtney Kiera Pride knew that Adam Moreno was a security officer fails, and you are not to consider the presumption for any purpose. 5. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 5th day of December 2021 in Bexar County, Texas, the defendant, Courtney Kiera Pride, did intentionally, knowingly, or recklessly cause bodily injury to Adam Moreno, and Courtney Kiera Pride knew Adam Moreno was a security officer, and that Adam Moreno was performing a duty as a security officer by striking Adam Moreno with the hand of Courtney Kiera Pride, and or by striking Adam Moreno with the foot of Courtney Kiera Pride, then you will next consider whether the defendant acted in self-defense and or defense of a third person and proceed to paragraph 6. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty and do not consider paragraph 6. 6, justification defenses, self-defense. You are instructed that it is a defense to this prosecution if the conduct of the defendant was justified by law. A person is justified in using force against another when and to the degree she reasonably believes the force is immediately necessary to protect herself against the other's use or attempted use of unlawful force. The use of force against another is not justified in response to verbal provocation alone. Reasonable belief means a belief that would be held by an ordinary and prudent person in the same circumstances as the defendant. Bodily injury means physical pain, illness, or any impairment of physical condition, including death. A person, 1, who has a right to be present at the location where the force is used, and 2, who has not provoked the person against whom the force is used, and 3, who is not engaged in criminal activity at the time the force is used, is not required to retreat before using force. If all 3 of these factors are met, then in determining whether such actor reasonably believed that the use of force was necessary, a finder of fact may not consider whether the actor failed to retreat. A person has a right to defend from apparent danger to the same extent as she would have the danger been real, provided she acted upon a reasonable apprehension of danger as it appeared to her from her standpoint at the time. Defense of a third person. A person is justified in using force against another to protect the third person if, 1, under the circumstances as she reasonably believes them to be, the actor would be justified under the law of self-defense as instructed above and using force to protect herself against the unlawful force she reasonably believes to be threatening the third person she seeks to protect, and 2, the actor reasonably believes that her intervention is immediately necessary to protect the third person. The defendant is not required to prove self-defense, and the defendant is not required to prove defense of third person. The state must prove beyond a reasonable doubt that the defendant did not act in self-defense and that the defendant did not act in defense of a third person. Now, keeping in mind these instructions, even if you unanimously find that the state has proven beyond a reasonable doubt that the defendant, Courtney Kiera Pride, committed the offense of assault against a security officer as charged in the indictment and as instructed in paragraph 5, you must decide whether the state has proven beyond a reasonable doubt that the defendant did not act in self-defense and that the defendant did not act in defense of a third person. Self-defense. Therefore, if you find from the evidence beyond a reasonable doubt that the defendant, Courtney Kiara Pride, committed the offense of assault against a security officer as charged in the indictment, but you further find from the evidence that, or you have a reasonable doubt as to whether at the time she did so, one, Courtney Kiara Pride reasonably believed, as viewed from her standpoint, that Adam Marino was using or attempting to use unlawful force against Courtney Kiara Pride. And two, have a seat.
Have a seat.
And two, Courtney Kiara Pride reasonably believed, as viewed from her standpoint, that her use of force and the degree of force used were immediately necessary to protect herself against Adam Marino's use or attempted use of unlawful force. And three, Courtney Kiara Pride's use of force was not in response to verbal provocation alone, then you will find that the defendant acted in self-defense and acquit the defendant and say by your verdict, not guilty. However, if you find from the evidence beyond a reasonable doubt that the defendant, Courtney Kiara Pride, committed the offense of assault against a security officer as charged in the indictment, and you further find from the evidence beyond a reasonable doubt that one, Courtney Kiara Pride did not reasonably believe, as viewed from her standpoint, that Adam Marino was using or attempting to use unlawful force against Courtney Kiara Pride, or two, Courtney Kiara Pride did not reasonably believe, as viewed from her standpoint, that the use of force and degree of force used was immediately necessary to protect herself against Adam Marino's use or attempted use of unlawful force, or three, Courtney Kiara Pride's use of force was in response to verbal provocation alone, then you will find that the defendant did not act in self-defense, but next consider whether the defendant acted in defense of a third person as instructed below. Defense of a third person. If you find from the evidence beyond a reasonable doubt that the defendant, Courtney Kiara Pride, committed the offense of assault against a security officer as charged in the indictment, but you further find from the evidence that, or you have a reasonable doubt as to whether at the time she did so, one, Courtney Kiara Pride reasonably believed, as viewed from her standpoint, that Adam Marino was using or attempting to use unlawful force against Jasmine and Zavette Hardaway, and two, Courtney Kiara Pride reasonably believed, as viewed from her standpoint, that her use of force and the degree of force used were immediately necessary to protect Jasmine and Zavette Hardaway against Adam Marino's use or attempted use of unlawful force. And three, Courtney Kiara Pride reasonably believed, as viewed from her standpoint, that her intervention was immediately necessary to protect Jasmine and Zavette Hardaway. And four, Courtney Kiara Pride's use of force was not in response to verbal provocation alone, then you will find that the defendant acted in defense of a third person and acquit the defendant and say by your verdict, not guilty. However, if you find from the evidence beyond a reasonable doubt that the defendant, Courtney Kiara Pride, committed the offense of assault against a security officer as charged in the indictment, and you further find from the evidence beyond a reasonable doubt that one, Courtney Kiara Pride did not reasonably believe, as viewed from her standpoint, that Adam Marino was using or attempting to use unlawful force against Jasmine and Zavette Hardaway, or two, Courtney Kiara Pride did not reasonably believe, as viewed from her standpoint, that her use of force and the degree of force used were immediately necessary to protect Jasmine and Zavette Hardaway against Adam Marino's use or attempted use of unlawful force, or three, Courtney Kiara Pride did not reasonably believe, as viewed from her standpoint, that her intervention was immediately necessary to protect Jasmine and Zavette Hardaway, or four, Courtney Kiara Pride's use of force was in response to verbal provocation alone, then you will find against the defendant, Courtney Kiara Pride, on her justification defenses of self-defense and defense of a third person, and find the defendant guilty of the offense of assault against a security officer as charged in the indictment. You are instructed that under our law, voluntary intoxication does not constitute a defense to the commission of a crime. For the purpose of this law, intoxication means a disturbance of mental or physical capacity resulting from the voluntary introduction of any substance into the body. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet, or computer, the internet, any internet service, or any text or instant messaging service, or any social media platform, internet chat room, blog, or website to include, but not limited to Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, or Twitter, to communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Written statements made by a witness to investigators or other officers or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can only send statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court in these instructions, are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions, which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, all 12 of you agree, the presiding juror was certified thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony, but you are bound to receive the law from the court, which is hearing given to you, and be governed by that law. In order to return a verdict, each juror must agree to that verdict, but jurors have a duty to consult each other and to deliberate with a view to reaching a unanimous agreement, if that can be done without violence to individual judgment. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at our trial. The law does not require a defendant to prove her innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you and these instructions, you will acquit her and say by your verdict not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty on the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the officer who has you in charge. Do not attempt to talk to the officer or anyone else concerning any questions you may have. Instead, address your questions to the court in writing. If you want to communicate with the court, notify the bailiff. Any and all communication relative to the case must be written, prepared by the presiding juror, and submitted to the court through the bailiff. Respectfully submitted, Judge Stephanie Boyd, 187 Judicial Court, Bexar County, Texas. Suitable forms are attached. State, are you prepared to proceed with your closing argument?
Yes, Your Honor.
All right, you may proceed.
Thank you.
Morning, ladies and gentlemen.
You sat with us for the last 2 days and you've heard all the testimony that's been presented, all the evidence that's been presented in this case. So I'm here to talk with you a little bit about the law that's going to be applied in the case before you go back and deliberate on this, on all the evidence. So when you go back into the jury room, you're going to elect the presiding juror who's going to be kind of the leader of your group and who's going to eventually return the verdict to the judge. You will make sure that you have all the evidence or all the testimony that you've heard. You can think about that, take that back with you. You can take back any photos, any videos that have been submitted into evidence. You can take all that back with you while you're deliberating to go over that evidence and think about it as deeply as you need to. One thing you won't have with you is any police reports that were submitted in this case. That's not evidence, although we may have referenced it. It's not evidence. Yes. So you will not be able to have any of those reports back in the jury room with you. And it also does not include any statements that either the state's attorneys or the defense attorney has made that hasn't been supported by any evidence. And one other thing that I'll tell you is that you should not allow any sympathy or bias against the state or against the defendant to be a factor in any of your deliberations. Now, the defendant was charged with assault bodily injury against a security officer. And as Mr. Escobar went over with you on Tuesday, these are the elements that the state has the burden of proving in this case. That on or about December 5th of 2021 in Bexar County, Texas, the defendant, Courtney Pride, did intentionally, knowingly, or recklessly cause bodily injury to Adam Moreno, who the defendant knew to be a security officer performing a duty as a security officer, by striking him with her hand or striking him with her foot. Now you'll notice there's a couple of ors in there. You only have to find that either the defendant intentionally, knowingly, or recklessly committed the act. You don't have to find all three, but as long as you can all agree that she acted as to either one of those states of mind, then that element has been met. As to the striking with the hand or striking with her foot, there hasn't been as much testimony presented or evidence presented as to whether she struck him with her hand with her hand. However, we have provided you sufficient testimony to show undisputed testimony and undisputed evidence that she did kick Adam Moreno in the foot. None of these elements here are in dispute. The defendant has never disputed any of those elements. She never denied that she kicked Adam Moreno. She never denied that she knew he was a security officer. She even states that in the video when she's in the back seat. Obviously, Adam Moreno testified that he was performing a duty by breaking up a fight that he heard going on inside the women's restroom. So all of these elements have been proven beyond a reasonable doubt. None of these are in dispute. And because of that, you must return a verdict of guilty. Now, the defense they've presented this argument to you that she was acting in self-defense. That's a smokescreen that's being put up. She wasn't acting in defense. She was interfering with Adam Moreno's duties as a security officer on that date. So when you go back and realize that we've proven our case beyond a reasonable doubt and you're considering any other arguments in this case, we want you to take into account credibility of the witnesses that have testified here. Look at their demeanor, how they were acting on the stand and how they were acting throughout the videos of any statements that were provided. Look at what motives they have into making any of those statements and look at what they actually said. There's been testimony presented by the defense that has changed over time. It hasn't been consistent. However, the testimony that you've heard from Adam, the testimony that you've heard from the officers that we've put on the stand has stayed consistent throughout since December 5th of 2021. So look at the consistency in those statements over time. Also look at the points of view that from the statements that are coming from the different witnesses. The officers have really no stake in the game. You heard from the officers that they're just there to investigate and find out what happened. Adam Moreno was doing his job. The defendant is the one charged in this case. So of course she's going to say she was acting in self-defense in order to protect herself from the charge. Look at the perception from where they were throughout the investigation and from where they were at the time of the incident and when they were making the statements that they made. And look at the time frame to see if their statements make sense, see if it adds up, and look at the time that's elapsed over time. So again, consistency. Look at how much time has passed. It's been almost 2 years since the incident and whose statements have stayed consistent over that duration of time. And finally, use your common sense in looking at the facts of this case. Does it make sense that the defendant was acting in self-defense when she stated she didn't know what was going on at first and jumped in to help her friend?
10 minutes.
Thank you, Your Honor. Or does it make more sense that Adam Moreno was doing his job and the defendant jumped in to interfere with that? And we're confident that you'll return a verdict of guilty after thinking about that. And Your Honor, at this time, we request to reserve the remainder of our time. Thank you. Thank you.
All right, defense.
Thank you, Your Honor. Ladies and gentlemen, good morning. So the law did not require that Jasmine Hardaway stand there and allow herself to be manhandled. The law didn't require that Courtney see her friend being roughed up by a security guard for recording that security guard and not get in there and try to help her friend and try to help her. And the law doesn't require that Courtney allow herself to be tackled and manhandled by Adam Moreno without defending yourself. And how do you know that? Because this is the law that you've been given. You've been given the law on what constitutes an assault. And, I agree with the state when they say that this, that they've proven their elements. You know why? Because Courtney got up here and she told you, yes, when he tackled me, I tried to fight him off. He was grabbing me. He was on me. He was manhandling me. He was on top of me. And what did she tell you? Yeah, I tried to kick him off. I tried to push him off. I tried to do everything that I could to get him off. So there's no doubt about that. This has never been about whether Courtney defended herself. It's never been about whether or not she kicked Adam Moreno. This is about whether or not the law allows her to defend herself. Because in this world, things happen quick. You can be walking down the street and someone bumps into you and they can call that an assault. You can find yourself in a position that you did not expect a split second before, react in a way that's completely reasonable, and then find yourself accused of a crime. And when that happens, the law says that you get to come in front of 12 people and say, you know what? This is what was going on, and I defended myself as the law lets me. Ladies and gentlemen, not all of our cases go to trial. In fact, very few of them go to trial. But Courtney Pride decided that she wanted a trial in this case. Every time we've been to court, Courtney said, I want a trial. Courtney is a young lady who has been to college, going to grad school right now. She's a single mom. She's trying to better herself. She works hard. She studies hard. She was raised the right way by a military father. You saw her. She was reasonable and respectful and appropriate in front of you. And when she dealt with Officer David out there, who was professional with her and considerate and respectful, all she responded with was respect and consideration and professionalism. She's also a young lady who apparently has a great deal of faith in the jury system because she wanted you to hear her case. Before she set eyes on you, before the 12 of the 14 of you walked in with 75 other people. She believed in you because she knew what had happened to her and she knew that it was wrong. And she wasn't going to do anything other than stand up and say, I'm not guilty of this. So she's put her fate in your hands. And so what did happen that day? We know what happened, right? We know that these two women were there. They were celebrating their friend getting her nursing degree, getting her education. We know that they had some drinks that night. No one has ever told you that they didn't. We know that Courtney wasn't drunk because you saw her on tape. She's emotional. She's upset. She's frustrated at the situation she's in because she didn't do anything wrong. And we know that really what this boils down to is two security guards who didn't know how to shut down the women's restroom without starting a fight. That's what this comes down to. And it's their job to keep order. It's their job to provide security. It's not their job to rough people up because they feel like it, because they're being recorded. And even though Adam Moreno jumps in because he sees that there's a situation going on with his partner, it doesn't mean that that situation was justified. So we know that closing time comes around. And Jasmine and Courtney decide they have to go to the bathroom, apparently with half the other women there that were at the bar, because that bathroom was packed. Even though Adam tells you there's only two people there in the bathroom, Jasmine and Courtney. We know from looking at the video, we know from Roberta Martinez testifying, who has nothing to do with nothing. She just happened to be there and happened to give her information to Courtney's mom, in case we wound up here. We know there's at least a dozen women in that bathroom. And we see Teresa Cardenas, the female officer, and she's in there and she's telling them, get out of here. Gotta go, gotta go, gotta go. And we know that she's in there banging on doors and telling people, if you don't get out, I'm putting my hands on you. Why do we know that? Because she put her hands on people. We know that they're in there using bad language because we've heard it from several witnesses. Either that or we have to believe Adam Moreno that they are like the only two security guards in the whole of San Antonio who don't use bad language, right? Probably the only two security guards in the whole world who don't use profanity. That wouldn't match any security guard I've ever met in any bar or any club. So when Teresa Cardenas, the female officer, is in there, and she's telling these women, you got to go, in colorful language and in no uncertain terms. Courtney and Jasmine use the bathroom. They're coming out. Jasmine hears, if you don't get out, I'm putting my hands on you. And she does what people do in 2021. She takes out her cell phone. She starts recording. And you can show that video. I had to show it to you. State didn't bring it, even though they had it. Because they're not going to bring in evidence that Adam's wrong. So you see on the video. And Jasmine, maybe she's handling it inappropriately, but she's just using words. Hey, TikTok, this is what's going on. And while she's doing that, what do we see? We see Teresa Cardenas come up and slap the phone out of her hand. And then we know what happens next. She puts her hands on her. She's gonna throw her out of there. Courtney's there. She's done it for over 10 years. She just sees what's going on. And she gets in there to try and defend her friend, to try and break this up, to try and avoid what's going on right there. And then there's a scuffle. And that's leads to the next thing that we know didn't happen. Because Adam Moreno tells you, I heard the sound of someone being choked in there. Actually, he doesn't say that. He says, I heard the sound of my partner being choked. How a man can be standing outside the room. The women are in the bathroom by the sink. And he can tell you that audibly he can hear so clearly and so distinctly and so accurately that he can tell you, oh gosh, that's Teresa, she's being choked. The fact of the matter is, he's halfway in, halfway out of that bathroom. They're trying to get these women out. Because even though his shift ends at 3, if they get him out by 2:30, they get to go home by 2:30. If they get him out by 2:15, they get to go home by 2:00. There's a scuffle and he jumps in because that's what you're trained to do, right? And when he jumps in there, his testimony is what? That the tall one, which would be Courtney, is choking Teresa from behind. And the other one is punching her in the face. So Miss Everhart, who works for PD, She was there. She took photos of everybody. Took photos of everyone's injuries. Did you see a single injury or a single photo on Teresa Cardenas? Because if that story is true, she'd have redness around her neck from being choked. She'd have bruises on her face from being punched. And we know that Miss Everhart took photos because I asked her, did you take photos of everybody? Well, just the two people, the two security guards and two people that were arrested. I took photos of all their injuries. So we know that that didn't happen because it's very easy to show you evidence. So what does Adam runs in there? Two women there having an issue with Teresa. He jumps in there, he tackles Courtney. And Courtney, you heard her testimony. This man comes in. First of all, she's flabbergasted as to why there's a man in the woman's bathroom. He takes her down. What does he say? I assisted her down. I said, what means you took her down? No, I assisted her. And I said, well, that's what the whole rest of the world calls taking someone down, right? Yeah, I guess it is. As if switching up the language somehow makes it better. And so he's on top of Courtney. She knows that Jasmine didn't do anything wrong. She knows that she's just trying to help Jasmine. And she's got this man on her. And she pushes him off. Is that unreasonable? She kicks him off. Because she's defending herself. She's terrified. This man's jumping on her. The law in self-defense is this, ladies and gentlemen. We look to see what a reasonable person would do. It's pretty reasonable. She got on the stand here. She didn't have to. Did she look angry? Did she look like a hothead? Did she look like somebody who's got a short fuse, who's out there looking for a fight? No, she looks absolutely the opposite. I asked her, how many times have you been to a bar? Yeah, a handful of times, 3-4 times a year. She's 30 years old, so she's probably been to a bar conservatively, what, 50-60 times in her 20s. Never had a problem with security before. She's never been arrested for getting into fights with security guards. I asked the security guards, this ever happened to you before? Yeah, it happens. What's the common denominator here? We've got security guards who have 40 hours of training. That's a week of training. You know, when you go to the police academy, it's like 12-14 weeks of training. And after a week of training, they get to decide when to use a gun, when to use pepper spray, when to use a taser. And even though they're not allowed to go around town acting like cops, in whatever site that they're working, they get to decide who to arrest, who to rough up, who to tase, who to pepper spray. Ultimately, they get to decide who to shoot, right? With 40 hours of training. They're the common denominator. So like I said, this is a story not of two women who went out and decided to disregard the law and assault two security guards. It's a story of two security guards who didn't know how to shut down a women's bathroom without starting a fight. Ladies and gentlemen, the state's asking you to convict this young lady of a felony offense for a situation that she could not have anticipated was going to happen 60 seconds more. For a situation she found herself in, and she reacted, number one, in a reasonable manner, and number two, within what the law provides her as her rights. If you are not provoking the problem, if you are somewhere you're allowed to be, then the law presumes that you are acting reasonably. And that's what she did that night. So who provoked the problem here? It's Teresa Cardenas. Even though Jasmine's annoying her, even though she's yelling, Teresa goes up there and knocks it out of her hand and puts her hands on her. And even though Adam Werner comes in and says, well, I saw this going on and I had to defend my partner, he's continuing Teresa Cardenas's issue. She's the spark there. Courtney Pride's put her fate in your hands. The state's asking you to convict her of felony, to make her a felon. They're going to ask you to sentence her somewhere between 2 and 10 years. This
2
may not be,
minutes.
thank you, Judge. This may not be a murder case. This may not be, a 2-month long trial in California. But I can tell you one thing without any doubt. That to Courtney Pride, this is the most important case going on in this courtroom. In this entire courthouse. And I'm asking you to give it that seriousness and to give it that level of dedication when you go back to and deliberate. What the law requires of the 12 of you that deliberate is this. Courtney's come up here and she's admitted to you, yes, I did fight him off. Yes, I did kick him. Remember how affirmative defenses work. You don't get to say, I didn't do it, but it was self-defense. You have to come up here and say, yes, I did it, but this is why the law allows me to do that to defend me. And she's defending Jasmine. And she's defending herself. And so at this point, the state had the burden of proving that an assault happened. And once Courtney comes up here and tells you it was self-defense, then the state has another burden. The state's burden now is to prove beyond a reasonable doubt that this was not self-defense. So if you feel like this was self-defense, unless the state's proven to you beyond a reasonable doubt that it wasn't self-defense, then your job is to find her not guilty. I want to be clear about it because it's a little tricky. Because the state kind of has to prove a negative. So you have to ask yourself, is Courtney reasonable? Did she act in a way that a reasonable person would act? Did she legitimately feel like she had to defend herself? Did she feel like she was in danger? And if you have any doubt about that, one way or the other,
Time.
then the right answer here is not guilty. If you don't know, not feel, not suspect, but know, then the right answer is not guilty. Thank you.
All right, state.
The state has met its burden by proving all the elements of assault security officers beyond a reasonable doubt. Now, as the defense pointed out, the issue here is self-defense. Now, it's the reasonable belief that Courtney had. Now, we can actually, this is interesting, because we don't always get this, but here we have her giving a statement little less than 30 minutes after all this happened. Her perspective on what happened. And immediately after, when she's given multiple chances to explain what happened and explain her side of the story, she's consistent in saying, I did not know anything about the whole Jasmine and Teresa thing. She did not know. She got up on that stand and she testified as to what happened. Now, a year and a half later, after she said she watched a 10-second video and that suddenly refreshed her memory, after she's had time to think and time to prepare, Adam came up here and he testified. He told the truth. He said that he did not see the beginning of this altercation. He heard it going on. He immediately turned around and saw Teresa being attacked by 2 people. He didn't know what was happening, but it's his job to enter into that restroom and to break things up, to detain people that SAPD can investigate, which is exactly what he did. There's been no testimony that he hit her. There's been no testimony that he tried to get her arm and twist it behind her back. There's been no testimony that he was using unreasonable force. He was attempting to detain her. And in attempting to detain her, Courtney decided to kick him in the face, busted his eyebrow open, left bruising all around. He could have been blinded. It's about an inch away from his eye. Courtney even acknowledged in her statement immediately given to Officer David that she knew he was security. She said, I know they're security and they are just doing their job. She knew what was going on. She didn't come up here and testify that she thought Adam was a complete stranger. She didn't come up here and testify that he just attacked her for no reason. It was in direct response because she was touching Teresa and Adam was trying to separate everyone, which was exactly his testimony. Now, you've heard several events or versions of these events from the defendant. You've heard what the statement she gave almost immediately after that she kept repeating over and over. You heard her testify and say, well, this is what happened. And I know it's different from what I said in the moment, but I've had time to think about it. Even while I was questioning her, she wouldn't admit to simple things. At first, she said Adam's in the restroom. Then she says, well, no, wait, Adam actually was outside the restroom. Well, no, wait a minute. Now he's coming in and out of the restroom. She changed her testimony to say, well, I was actually outside the stall when this all happened. Defense has also been bringing up Teresa. There's a reason why there are no photos of her. She's not the victim here. It's Adam. He's the focus. He's a completely separate person. They're not acting together in a group. There's been no testimony that they both decided to do this. It's what happened to Adam, not what happened to Teresa. There's been no testimony that Courtney committed her actions because she was trying to defend Jasmine from Adam. Nothing. Can't even really consider the defense of a third party. On her own self-defense claim, she again says, I did it because he was trying to come at me. But she never says that he hit her, never says he kicked her. She knew he was security. He was trying to detain her and do his job. Defense also brought up Roberta Martinez, who was the witness that came in via Zoom. And we allowed that. She testified and gave her version of events. But then after cross, she immediately said, well, I didn't say that. Well, actually, I was in a different area than I told you guys. Well, yeah, I was actually in a stall with someone else and I kind of left that detail out. Well, I didn't actually see what happened because I was in the stall. So you can completely disregard Roberta. The biggest issue that defense has pointed out with Adam's testimony is that he said they were the only two in the bathroom. That's it. That's all he misremembered. Everything else was consistent. The funny thing about that video that defense mentioned, that little video that Jasmine took as she's kind of in the bathroom twirling around, I want you to look at that. Where's Adam? Not in the restroom. He's not there. He came in later. This case is about whether or not did she reasonably believe that Adam was trying to use unlawful force. Adam testified he was trying to detain her. She testified practically that he was trying to detain her because all he was trying to do was get on top of her and restrain her. And what does his action show? He did just restrain her for SAPD to investigate, which is why we're here today. You cannot let bias or sympathy play a role. The reason why this is coming to court is so that Courtney can face the consequences of her actions. That's why we're here. I'm asking that you find her guilty of assaulting of a security officer. Thank you.
All right, ladies and gentlemen, I had continuously given you instructions about not to deliberate, not to deliberate in your mind. Now is the time for you to go to the back to select your foreperson, and then you have the court's permission to begin deliberation. I'm going to ask that Mark Pettis and Sophia Arian stay behind, please. All right, everyone, please rise for the jurors.
So, but yeah.
Who is here on Christopher Anthony?
Need to. Judge, the defendant's here, I don't think the lawyers.
All right, just have a seat.
Have a seat.
All right, everyone, do not, the rules are still the same. Do not approach unless you've conferred with the state. If you have a client who is in custody, ask the deputies will bring them out. If your client needs an interpreter, do not leave once you requested the interpreter because we have a limited number of interpreters. All right, who is here on Robert Castillo?
More, Your Honor.
Good morning. Did you have a chance to confer with the state on this? All right. Good morning. All right, so does the order specifically state the limitations? All right. If you all want to put your agreement in the order, and then the court will sign it. Everyone, please whisper.
These are family bonds.
Yes.
They'll have CTV over there. I don't know where they have them, but they're boxes.
All right, so with regards to the release of the personal property, I can see with regards to the work boots, I don't know if something happened where he got out of the vehicle, left, and there's something on the work boots, or if there's something on the camera or with the lens. So state, when can you have whoever's looking into this case, look at the work boots, make a determination whether the work boots have anything to do with this case, make a determination whether the camera body or the lens has anything to do with this case, because if it doesn't have anything to do with this case and he needs it, obviously work boots, he needs them from work. And from my relatives who have work boots, I know those are very expensive. So how much time do you think you'll need for them to? All right, so how much time are you thinking? All right, so on this, we'll reset it for 2 weeks and state if you have that information beforehand, just let defense know, and then you all don't have to come back in. Not for the release of personal property. Ms. Ferguson, on Robert Castillo, it's not an indicted case, but could you make this, place this on the docket in 2 weeks? And if you'll give that to Ms. Ferguson so that she will give you a date. You're welcome. And then once you all sign off on that order. Lucio Abala, if you'll have Mr. Abala come forward.
Let me grab it real quick.
Mr.
Good morning.
And Tom.
Hey, Anton, how are you doing?
If you all can slide, yes. Yes, the BTC, what's happening with that? Oh, just 1 second. Let me see if I can email and have someone come down. So just have a seat.
Sir. How you doing? I'm feeling real good this week. I went on vacation last weekend. Yeah, I should do it more often.
Helping. I'll make like a deferred offer on this.
Oh, thank you. Yes.
Oh, yes. Sir.
Yeah.
All right, are you on that one, Steve?
Here's this.
I'm on this Vargas guy, Barnum.
Nope. Keith, watch out.
Who's here? I'm Tony Murato.
Yeah. Just take my time. It's okay.
Hello, where's your client?
You guys.
Oh, to the
Well, he's a new number one,
Okay.
but you're gonna love the new number one. Oh, this is your chair.
All right. All right, we're gonna go on the record. Court is calling 2022 CR 8639, State of Texas versus Tony Leanne Murato. Can I have parties announced for the record?
Jason here had
All right, this hearing was scheduled at 9 a.m. It is now 10:09 a.m. The defense has informed the court that the bondsman surrendered his surety on this particular defendant. Your client is not present. Do you know where your client is?
As far as I know, no, she's not present and I have not had any contact with her since she's released.
All right. I'm going to ask then that she be remanded without bond. And if your client makes an appearance, of course, the court will reconsider the remand without bond.
Yes, sir.
All right, thank you.
Any issues?
Yes.
Thank you.
Okay. And counsel, I'm so sorry. Since the surety got off the bond, did you check to see maybe if she's at the Bexar County Jail?
I actually looked online, Judge, and I didn't see that. I saw warrant status. but I
Okay.
can confirm with her.
All right. Okay, thank you. Caroline, can you make sure there's a remand without bond with my name on it and with the security? Thank you.
Is she coming in or?
So anyway, yeah. Oh, it doesn't seem like there's been anything. Okay.
All right, Bashan,
Fires wherever they need.
John Herman is going to be here in about 5-ish minutes. Hi, he's here.
You need the mic, it's on
We have the
that.
deposition.
Thank you so much. Hi. What's wrong with your foot?
I made a fracture last week. So I'm learning my body to breathe out when I power through it. So
Okay. All right, so we have here Lucio Avila.
he's in it.
Lucio Avila. He said he was set here in May 1st and recalled. They're saying that they had put in information for VTC, but they don't have any information.
So we're still running through the referrals. Pretty much what I signed last week, February until about last week, the judge had me stop everything. So he reopened it up. So the VJOs and I are running about 4 weeks. We're still trying to clear out March and April. So if it was sent to me in about May time, I'm getting to it as quickly as I can. But right now we're trying to clear out the ones on top.
So how much time do you think you need for me to reset this to?
Can you run me the case? What's the charge?
Oh. No problem. Do you need us 30 days? Do you need a sticky note? All right, I'll give you a sticky note with the name and everything. Oh, no problem. Lucio Avila, can you come forward, please? And do you need,
I'm the coordinator for the felony VTC. You're on my list. I haven't forgotten about you, but we're still trying to work through a few referrals. What I want you to do is I'm gonna talk to you right after the judge is done. I'm gonna talk to you real quick about sending a few documents. And then we're gonna get you out.
All right, Ms. Ferguson, can I have a 30-day reset on Lucio Avila and it's for VTC? You know what? Actually, put it at 45-day mark. All right, so you'll be back here on July 20th. And Mr. Herman is going to give you the information to make sure he has your contact information and you have his, okay?
Yes, ma'am.
All right, so his attorney, I think, stepped out. So if you can just make sure he has his reset form. Luciel Avila. Hi,
Got a minute?
sure. All right, thank you. Yes. Norma, give me 2 minutes.
Every time. What's your name, company? Lucio, Javi? Yes.
All right, who's here on Mario Pineda? Are you all ready or no? All right, just continue to talk then. Bud Ridenour?
Present, Your Honor.
Yes. Who are you here for, Mr. Ridenour?
Paul Duncan, recall he is in another county and we were going to have a motion to an MTR setting, and you were, hopefully the jail was going to put him on Zoom as well. I forget.
All right, which county is he out of?
Williamson County.
All right, just give us a moment. Ms. Ferguson, do you know if Williamson County is connected in?
I have not got a response from him, county judge.
Okay.
So I can call him Monday, I can try again.
All right, so Mr. Rittenhour, we haven't received a response from Williamson County. Are you available to do this on Monday?
Just a second. I've got a number of settings in the morning, but I'll work it in. In the
All
meantime.
right. I mean, if Monday is bad for you, Ms. Ferguson, if Monday is not good for him, can we do it on a different? What
We can
day
do
would
it.
you like to have him here? Mr. Rittenhour, what day?
Wednesday, the 7th?
That's not a good day for the court because that's our jury trial day. So
Oh,
any day but
goodness.
the Wednesday.
Can we do it in an afternoon? No.
That's bad.
Well, Judge, I'll tell you, Monday I have 4 settings.
The only
They
thing
are
about-
all initial. So I probably can do that and just tell the other courts I'll be late.
No.
Especially
Here's
if
the
I
thing.
could-
We will put it on Wednesday, the 7th, but if we put it on Wednesday, the 7th, it has to be exactly at 9 a.m.
That's not a problem.
All right. So we'll do it on Wednesday, June 7th at 9
Okay.
a.m.
And I assume the prosecutors are all live, so I can't confer with them on Zoom. I'll have to do that separate, correct?
Yes,
Okay.
if you want, just call them. They're very responsive.
All right, I'll do that, Judge.
All right. Thank you.
Thank you, Judge.
You're welcome. Could I see the file on Paul Dumpkin? state on Paul Duncan, since he's in custody in Williamson County. It's going to take place by Zoom on June 7th. So if you can confer with the defense counsel off docket. Okay, good. All right, thank you.
We're gonna get it right.
I know.
We are gonna get this right.
Deputy Laura, you're awesome. Diana, I hope I wasn't reading too fast. I tried not to. Yeah, it is.
Judge, can I approach?
Is it on Adam Rafferty?
It is not.
Just give me a moment then. Who's here on Adam Rafferty? All right, if you'll come forward, please.
I know my time's are winning.
All right, and defense, you're on this side.
Oh, have this, Judge.
Okay. Thanks for dressing appropriately for court. How do you pronounce your last name?
Rafati?
Rafati?
Yes.
So I pronounced the T?
Yes.
Okay. All right, so we're here for PTD. Where are we on that?
He has entered the PhD program. Judge signed the contract today and it was accepted, so we should be good to go. I believe we're getting a 30-day reset just to make sure that everything goes through and the case is discussed.
All right, Ms. Ferguson, could I have a reset date on PTD for Rafferty? All right, we'll come back on July 6th. Just get the reset form from Ms. Ferguson and your excuse.
Thank you, Judge.
All right, thank you. All right, who's here on Jess Moffness? All right, if you'll have your client come forward. All right, this is for PTD. Where are we on this?
Yes, Judge, we've submitted the application and I believe it's already approved.
Yes, Judge, I did speak with our supervisor yesterday. It will be approved. We're just waiting on the application to be filed. So we're just, probably just need a quick status date on that to make sure that it gets sent through.
All right, Ms. Ferguson, I need a PTD date for Moffness.
And Judge, we submitted it this morning, so they have it.
All right, so we'll come back on July 6th. Just get a reset form and you're excused.
Okay, thank you, Judge.
All right, thank you.
If we put the agreement already and have it signed, can I get that reset?
Oh, just get the reset form from Ms. Ferguson.
Okay, thank you.
Thanks for dressing appropriately for court. Who's here on Thomas Toledo? All right, so where are we on this case?
Your Honor, I've spoken with counsel. We have not gotten in contact with the complaining witness. She does have information in order to get in contact with the complaining witness. So we just asked for a short reset so we can speak with her to determine whether or not we're going to be proceeding on this case.
All right, you all can't get on the phone today?
If she's available.
We can get her on the phone.
All right, let's see if she's available today.
Thank you, Your Honor.
All right, thank you. Oh, they're not ready.
We're ready.
Norma, what date did we give Lucille Avila? I know it was in July. July 20th?
75 days.
Yes, all right, thank you. Dominique Brinkley. Dominique Brinkley. Devin Magallanes. Devin Magallanes. Yeah, I don't have the file. Oh, thank you. I was just like. No problem. Let me see some.
You never hear it's going to be some of that.
Who's here on David Burnham?
I am, Your Honor. We're ready. We have a plea agreement.
All right, could I have the parties on David Burnham?
Yeah, remain seated, Your Honor.
Yes, sure, but move over to this side.
Okay, we'll get it figured out.
Court is calling 2022 CR 10910W, State of Texas versus David Wayne Barnum. Can I have parties announced for the record for the state
Jason Garahan, Your Honor.
defense?
Anton Hike for the defense, Your Honor.
All right, and are you Mr. Barnum?
Yes, ma'am.
Am I pronouncing your last name correctly?
Barnum, yeah.
Barnum. All right, I'm going to show you a document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same David Wayne Barnum who was placed on deferred adjudication in 2022 CR 10910W for the offense of unauthorized use of a vehicle on November 16, 2022 for a period of 5 years? Is that you,
Yes, ma'am.
state?
Ma'am.
Violated condition number 1 on or about
Yes, ma'am.
the 23rd day of April 2023 in Bexar County, Texas. The defendant David Wayne Barnum committed the offense of possession of controlled substance and violation condition number 1.
How do you plead to that? True or not true?
True.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there an agreement?
There is, Your Honor.
And what is the agreement?
The agreement is to deny the motion to adjudicate guilt and continue the individual on his deferred, to alter and amend to include state ISF substance abuse track. The state's not opposed to a drug court, a felony drug court for that matter also, Your Honor.
All
And
right.
the state will take into consideration cause number NIGHTMAC 709-792, which is pled true to.
All right, Mr. Vernon, are you asking the court to follow that agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right, so what is your drug of choice?
Methamphetamine.
All right. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
David Barnum,
All right. So how often are you using?
every day.
Do you have any family for support?
I do. They're here with me today.
All
They're
right.
back.
And who is your family here with you today?
My grandmother, Kate, my brother Michael, and my mom Lisa.
Okay. All right, so I'm going to give you a choice because some people say they want help, but then they don't really want help. So it's clear to me that you do need inpatient treatment. Felony drug court is a good program, but it's 2 years. So I can give you your inpatient treatment, or either I can revoke you and send you to the state jail facility. And let me just tell you what will end up happening. If I send you to the state jail facility, you're going to come out. You're going to have every intention to be great, to be successful, not use again. But what I've discovered is when people don't have treatment, they get out of state jail or get out of prison and they immediately start using. So do you want the help?
I want the help.
All right. So I'm going to refer you to felony drug court. I'm going to deny the motion. The first thing I want to see if felony drug court will accept them, you need to be 100% honest with them, because if you're not, they're not going to accept you because there's a limited amount of space. Okay. All right. So we're going to do a referral to felony drug court. And if he's not accepted, then we'll do a state ISF, substantive and cognitive track. And then that's going to take place while in custody. And upon release, we're going to do the UA hotline with him. And if you are released, who are you going to be staying with?
I'll be staying with my mother.
All right. Have you gotten permission to stay with your mom?
I have.
Okay. So, Vashon, if you can make sure you get the address for his mom, that's where you're going to be staying. And you're not going to be allowed to leave unless you get permission from the court. Okay.
Okay.
Of course, if your mom ends up kicking you out, that's a different story. You will still, if she kicks you out on, a Wednesday, you need to immediately let probation know, and then we'll address that issue. Okay.
Okay.
Is there anything else you need from the court to be successful?
Sounds.
All right. You're lucky to have your family here. Sometimes family members don't show. Okay. All right. Probation will go over conditions with you. Good luck to you.
Thank you, may I be excused?
You may be excused.
Sure.
Just let them run you around, whatever it's gonna do.
And but Sean, with the UA hotline, that'll be weekly testing.
Okay.
Thanks for showing up for him.
That's his family standing up in the back.
Yes. All right, who's here on Andy Maldonado?
Morning, Judge.
Good morning. If you have your client come forward, stand in the middle, please. All right, so on this case, we were here on May 4th, cell phone download, recall for June 1st for cell phone info. Where are we on this?
So, they did download the cell phone. However, the USB that they downloaded it onto, there was some kind of technical issue with it, so they're having to download it again on USB. So I still haven't been able to give it to defense counsel, but it is, the dump has now been completed, because last time we were here, they hadn't finished the actual physical dump of the phone. So now it's just a matter of, I forget the agency, but the agency getting us a working copy of the USB so that I can Kirby so that I can give a copy to Mr. Kettner.
And when is that going to be done?
It should be soon.
And next week soon?
Let's put it on next week. I think I would prefer that because then I can put more pressure on them.
All right, Ms. Ferguson, can we recall this for next week, please? And it's discovery. All right, we'll be back on June 8th.
Perfect, thank you.
Thank you, Judge.
Thank you. This is Maldonado.
Thank you, Judge.
You're welcome. Andy Maldonado Rivera.
I got a video. There's a fake video.
Why don't you, let's all put our cards forward.
Who's here? I'm Robert Andrade.
You're gonna. Hearing,
Yeah,
whatever the rule on that is, we can go through that again.
All right, so I have a sticky note. You all, on the paperwork, the wrong case number was placed.
it might be another version of it because it was dismissed and reindicted, so.
Yeah.
It may actually go with it, but it's not the correct.
Oh, it may be the old case number.
Yes, so the case number should be, and you put the proper case number on the application. So it should be 2022. Well, actually, you didn't put the right number. It's supposed to be 2022 CR 8174. So if you all would like to initial.
Happy to, Judge. I just didn't want to do it without you telling us how you wanted to.
All right, if you all will just initial the correct cause number and write the correct cause number, and we'll take this up.
Okay.
Caroline, thanks for catching that. I did. And Caroline, that's the thing, I have to see clear numbers. After this case, the next one is going to be Eduardo Gallardo. Then it will be Mario Pena, Gracie Segunda, Mario Miranda. Oh, and counsel, I need the court's file. Court's file.
This is on another case.
No, yeah.
Me.
Oh, that's.
That's like court's file, where is it? Hi, how are you doing? All right, the court is calling 2022 CR 8174, State of Texas versus Robert Andrade. Could I have parties announced for the record for the state
Brittany Mitchell for the state.
defense?
Raymond Martinez.
And are you Robert Andrade?
Yes,
You entered a plea on April 17th of no contest, applied for probation. You entered a plea to the lesser included offense of harassment as a Class B misdemeanor. According to the agreement, punishment is to be assessed at 2 years, and the state is recommending community supervision. Have both parties had a chance to review the PSI report?
I have, Judge.
The state has been made a copy. I have not personally reviewed it.
All right, any objections to the PSI report?
No, Your Honor.
Judge, Mr. Andrade says that between 2011 and 2017, he was in TDC. There appears to be some cases in the history during that period of time that don't belong to him. I think it's another person with the same name with a different SID number. So if there are any cases between 2011 and 2017, we do not claim those cases.
All right. Anything you wish to say on behalf of your client?
Judge, Mr. Andrade has expressed numerous grievances in his pre-sentence investigation. I can say that I agree with most of them. We've been very frustrated with the.
Second, everyone, we are on the record. If you cannot whisper, you're going to have to stop talking and do not speak behind the court reporter. You may continue.
He's been very frustrated with the delays. Part of it was dismissals and reindictments, modifications of indictments. I will say it's not the state's fault. I think they had a complainant that was manipulating and abusing the system. Mr. Andrade at this point just wants it to be over. He has a Class B misdemeanor, which he's ultimately pled to, which carries a maximum of 6 months in the county jail. He has more than that amount of time in jail. And he has over a year on a monitor. Very difficult time on the monitor, very difficult working, very difficult getting permissions. We've been here many times on monitor issues, all for us to come down to a Class B misdemeanor. So that's why he has frustration and grievances, and I understand them. He'd like to have this be over. So grudgingly, we will accept the plea agreement and ask the court to follow.
All right, well, I mean, grudgingly, he accepted it. I don't do the adverbs or the adjectives. He accepted it. So I do see in the PSI report that the complainant has not prepared a victim impact statement or keeps promising that one will be done. All right, Mr. Andrade, you are employed, is that correct?
Yes, ma'am.
Okay. All right, state, anything you wish to add?
No, Your Honor, we just asked that you follow the plea agreement.
All right, then, we're going to go off the record for a moment. The punishment that you all are at. And Mr. Andrade, can I have you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. I need you to speak up. Could you state your name?
Yes, ma'am. Robert Andrade.
All right, Mr. Andrade, you do understand that the range of punishment for this offense at most is 180 days in the Bexar County Jail?
Yes, ma'am.
And you understand that in the plea bargaining agreement, the state is asking that your punishment be assessed at 180 days in the Bexar County Jail. But they're recommending probation. And they're asking that your probation be for a period of 2 years. Do you understand that if your probation were revoked, the court could sentence you up to 180 days in the Bear County Jail?
Yes, ma'am.
All right, do you understand that to be the plea bargain agreement?
But I have more than 180 days.
No, I'm just telling you what the plea bargain agreement is, and I'm trying to figure it out if you understand it. So do you understand that if for any reason you were revoked, the court could sentence you up to 180 days in the Bear County Jail? All right, and you understand that to be your plea bargain agreement?
Yes.
Okay. All right, this is what the court is going to do. The court is going to all right. My understanding from Ms. Abrams is that the complainant has called in. She says she doesn't want to make a statement, but she does want $2,300. I don't know what the $2,300 would be for, but the court is not going to impose restitution without some documentation for restitution. So we can have a hearing on the restitution amount, but the court is not opposing restitution. I will say restitution, if any, and then counsel, if restitution is given in the form of documentation and you want to contest that, we can have a hearing on that.
And Judge, just for the court's benefit, she does address that in her comments that she wants some compensation, what she calls it, I guess, for being harassed.
If I could shed some light on it, obviously this was a reduction there was a grander scheme of things that led into this case, and one of them was damage to her property, Your Honor.
Okay. All right, so court is going to sentence you to 180 days in the Bear County Jail, suspended and probated for 2 years. There's to be no contact with Heidi Coleman. Restitution, if any, to Heidi Coleman. There's an affirmative finding of family violence. The BIPP course. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Regular UAs. Regular reporting by Zoom or in person. And probation, I'll do one field visit. And if everything is okay with that field visit, then the probation can discontinue the field visits. Probation, is there anything else he needs? Mr. Andrade, is there anything else you need from the court to be successful? All right. I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes.
All right, because this is a plea bargain agreement, because I call it your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, just remain in the courtroom. Probation will go over conditions with you.
And Judge, just so that everybody's clear, is he now released from pre-trial conditions, including the GPS monitoring?
State, do you have any objections to the removal of GPS?
At this time.
All right, can I see the phone? Just let the complainant know that GPS has been removed.
Okay.
All right, is there anything else?
No, thank you, Judge.
You're welcome. Yes. Who's here on Eduardo Guarda? Eduardo Guarda. All right, so today the state was to make an offer. Was an offer made?
Yes, Judge.
All right, Ms. Ferguson. I need a 2-week reset on this case for a plea deadline date. It's Eduardo Guarda. All right, so we're going to be back on June 8th. Mr. Guardo, at that time, you need to let the court know whether or not you're accepting the offer that's been tendered, okay? All right, just sign the reset form, then you're excused.
Yes, Your Honor, thank you.
You're welcome. Who's here on Mario Pineda? All right, we're here for medical records and your client is by Zoom. Yes, where are we on the medical records?
Judge, we've received them. We're gonna provide, there are some redactions that have to be made to the medical records. But we're gonna provide them to defendants. I'm probably gonna leave them at the 4-4 window tomorrow.
Okay,
And then the only other thing, Judge, is that we did need some time. There are a few witnesses in this case that we have not had the opportunity to speak with yet.
all right, Ms. Ferguson.
Affidavits. Yes, we had some affidavits that were provided to the misdemeanor court. I don't know if they've made their way up. I don't know if they've been sent to this court yet.
All right, Ms. Ferguson, give them a 30-day reset. At that time, the state, you need to be prepared to make an offer.
Yes, Judge.
All right. All right, we'll be back on July 6th. And Norma, note for the record that Mr. Pineda is in Houston.
Yes, Your Honor.
He can appear by Zoom.
And Judge, was it discovery or pre-deadline?
No, it is for the state to make an offer.
And Judge, just so the court's aware, there is a co-defendant in this case. I don't know if the file's right underneath that one, but it's the same.
Yes,
All right,
and
Gracie Segunda, where is she?
yeah, Your Honor, she's set for the 5th. I do have her on standby, just in case, because I realized you called her earlier. But she does have a court date on the 5th.
All right, and she Houston as well?
Yes, Your Honor.
All right, Ms. Ferguson, and can you put Gracie Segunda on July 6th as well? All right.
Does she need to appear on the
5th? No,
5th? Okay.
but make sure that she's
July
on Zoom.
6th. Okay.
Thank you, Judge.
All right, and there's no outstanding discovery in that case as well?
I think it's the same issue with the medical record, so it's just gonna be, in essence, the same copy. I can just leave 2 copies.
All right,
Yes. Okay.
all right, so Mr. Pineda, you're excused.
Thank you, Judge.
You're welcome.
Excuse me, Your Honor.
Yes.
Thank you. Oh, do I need to get the reset from you? Okay.
Next. Thank you.
See that?
And Norma, can you make sure that this is the same? Oh, that these are the same dates. Caroline, do I have time? I do have to follow Thomas Toledo. Thomas Toledo. All right, state you had a chance to speak to the complainant.
Yes, Your Honor. We are dismissing the case at this time.
All right, and what is his relationship to the complainant?
Your Honor, they were in a relationship at the time of the allegations. I'm unclear if they're still in a relationship.
There is a no contact order at this time, Your Honor, so they have not been in contact. I don't know if they plan on continuing their relationship after this.
All right, Mr. Toledo, I have no jurisdiction to tell you what to do, but what I can tell you is when you end up in criminal court looking at potentially 10 years in prison, maybe that's not the relationship you should be in. You understand? All right. Good luck to you.
Thank you, Your Honor.
You're welcome. Norma Toledo was dismissed.
Thank you.
Who's here on Mario Miranda?
I am, Your Honor.
All right, Mr. Miranda, come up. So, Mr. Sawyer, always good seeing you.
Good seeing you. We've conferred on our final comments with the state. Your Honor.
All right, so what is happening with this case?
Need to put on the trial docket, Your Honor.
All right, state, how long do you expect this trial to be?
2 to 3 days, Your Honor.
All right. Ms. Ferguson, could I have a trial date on Mario Miranda? It's family violence.
We can move to impact on June.
All right, so we'll be back on June 12th for jury
June
trial.
12th.
And it'll
Thank you,
be
Your
an
Honor.
impact court.
Okay.
All right, thank you.
Excuse you. Your Honor.
After he signs the reset form, you're
Yes, ma'am.
excused. Always good
Yes,
seeing you. How's your wife doing?
Good.
Oh, that's
It's
good.
my hand that needs to improve.
Oh, my gosh.
Thank you.
All right, thank you. Tell your brother I said hi.
I sure will.
John Carlos Torres Rivera. All right, today is the plea deadline date.
Good morning.
What's happening? Good morning.
He's not taking the plea, Your Honor.
All right, Mr. Torres, you want a jury trial?
Yes.
Okay, so here's the thing. Your attorney can't decide for you if you want to go to trial or not go to trial. That's one of the things that are in your purview. Okay, you understand?
Yeah.
All right, so have you received the offer from the state? I don't know, want to know what the offer is. I just want to know if the offer has been tendered to you. All right, do you understand the offer? All right, so the next question is, do you want to accept that offer or do you want a jury trial? All right, so state, how long do you expect this trial to last?
Approximately 3 days.
All right, Ms. Ferguson, it's family violence. I need a jury trial date on Torres Rivera. All right, your jury trial date is going to be July 11th. You will be brought over dressed for trial in whatever civilian clothing you have at the jail. If you wish to be attired in something different, you need to make arrangements with your attorney and you need to sign a clothing exchange. You understand? If there's an issue with the clothing exchange, let the court know. All right, thank you. And before you all leave, you need to do an acknowledgement of discovery.
Yes, Your Honor.
All right, thank you. Jose Torres. Yes. All right, you're on this side. Counsel, you're filing a motion on yourself saying that you're ineffective.
No, I filed a motion. I'm retaining Your Honor.
No, this says motion to withdraw plea due to ineffective assistance of counsel.
He
Yes.
was not the attorney.
All right. All right, then you have witnesses that you're going to call?
Yes, Your Honor.
All right, court is calling 2022 CR 11241, State of Texas versus Jose Angel Torres. Could I have parties announced for the record for the state,
Brittany Mitchell for the state.
for the defense?
Adam Flores for the defendant, Your Honor.
And are you Mr. Torres? All right, the defense counsel has filed a motion to withdraw plea due to ineffective assistance of counsel, stating that the plea was not entered into freely and voluntarily. Is that correct?
Correct, Your Honor.
All right, do you have any witnesses?
Yes, Your Honor.
Who?
Sister. And he was testifying.
All right, all right. We'll call the sister, although she's not a party to the contract. What is her name? Counsel? All right, come forward. Yes. Can you raise your right hand for me?
Yes, ma'am.
Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. You're going to need to speak up so the court reporter can hear. Can you state your name for the record?
Yes, my name is Mariela Guadalupe Torres.
All right, I'm sure she didn't understand the first name. Could you repeat that?
Mariela,
All right, and could you spell your first name?
Mariela.
All right, defense?
Yes,
How do you know the defendant Jose Torres?
He's my brother.
Okay. And you've been going to court with them?
Since the first time he's been here.
Okay. How long you have known your brother? How long have you known him?
My whole life,
Okay,
37 years old.
okay. And did your brother finish high school?
No, he did not.
Can your brother read?
Not as well.
Does your, when he was in school, was he in special classes?
Yes.
What kind of special classes he was in?
He was actually in special classes of taking care, not reading right, can't spell right. He does have hard time to understand things as well.
Okay. And I was not the court appointed attorney that was assigned to you for this case, but did your brother convey to you that the court appointed attorney didn't review discovery with you or evidence?
No, sir.
Subject to hearsay.
Sustained.
Okay. And did your brother tell you that, I'm
To
sorry.
hearsay.
Okay.
Sustained.
Does your brother understand what's going on here?
No, ma'am. No, sir, at all.
And no further question.
Any questions?
No, Your Honor, not of this witness.
I have a question. Is there any objection?
No.
All right. Do you have any legal documentation where you are in charge of your brother's legal affairs?
Not at this point.
No,
Your
that's
Honor.
either yes or no.
No.
Have you gone to a court to have yourself declared your brother's legal guardian?
No, Your Honor.
All right, thank you. Any other questions?
No, Your Honor.
No, Your Honor.
All right, thank you. Defense, call your next witness.
I call Mr. Jose Torres.
Oh, thank you.
All right, could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth? So help you God? All right, you can lower your hand, state your name for the record.
Jose Angel Torres.
All right, defense.
Yes, Mr. Torres. Did the court appointed attorney review any discovery with you?
And discovered,
Any evidence with you?
no, sir. He reset my court date 4 times,
Okay. Have you gone to his office?
1 time.
And what did he say to you?
He was swamped with clients and his assistant had quit on him. And we did not go over any evidence whatsoever. And
Why
while I was
didn't-
office,
Why you didn't go over evidence with you?
I have no idea, sir.
Okay. Did you ask him to review evidence?
No, I did not.
Okay. Did he show any videos to you?
No, sir.
Do you know did he tell you has he seen any videos?
No, sir.
Okay. Do you know there's a video the state has? It's called a state video, I guess.
No, I did not know that.
Okay. When you played out, why you pled guilty for or no contest?
No contest because I thought it was not guilty.
Okay.
Because I asked him when I went to his office, and he asked me, did it ever happen? I said, no. He said, plead not guilty. Since the resets, now the last time I came around, he told me, hey, no contest.
Do you understand what's going on here?
Not that I'm not aware of that much, so.
Okay. Do you understand when the court says there's a cap of 4 years? Do you know what that means?
Yes, stay tough.
Okay. What does that mean to you? What is a cap of 4 years?
Prison,
Prison, okay. Did he promise you probation?
yes. Yes, he did.
What kind of probation he promised you?
I think it was 2 years.
Excuse me, are you chewing gum?
I know. Yes, 2 years. I forgot. Yeah. So,
Okay. Did you finish high school?
no, sir.
Why you didn't finish high school for?
I dropped out for working.
Okay. Can you read?
Not much, not as much, sir. No.
Okay. When you were in school, what kind of classes were you in?
Regular classes, and half the time I was in special classes.
No further question. Your Honor.
Any questions?
Well. No, actually, no, just argument.
All right. Is this your last witness?
Yes, Your Honor.
All right, the court will hear argument.
Yes, Your Honor. The defendant was not, he didn't, the court appointed attorney did not review evidence with him, Your Honor. There was an implied promise that he's gonna get probation based on his plea. He told the court appointed attorney that he was not guilty, but
All right, counsel, you are aware
yes,
that in this court, I go over in great detail the plea bargain agreement. And after I go over the plea bargain agreement, I ask all the parties, including the person who's accused, whether or not they understand that to be the plea bargain agreement.
yes, Your Honor.
So you know I would have done that in this case.
Yes, Your Honor.
All right, you may continue.
Okay. And also, Your Honor, the client doesn't, Mr. Jose Torres doesn't understand what's going on here. Your Honor. He doesn't understand the procedure. He doesn't understand why the attorney didn't review evidence with him.
Are you saying your client is currently incompetent?
Yes, Your Honor, right now he's incompetent. I did file a motion.
So you called a witness to testify that you believe is incompetent?
Well, Your Honor, I did, the way I perceive him, Your Honor, I did file a motion for a competency hearing. So,
So you don't think he's competent, but you called him as a witness?
well, Your Honor, I have to. Well.
All right, what the court will do is the court will state, I'm assuming, well, let me not make any assumptions. Are you in objection to the withdrawing of the plea?
I am in objection to it, Your Honor.
All right, so with regards to the defendant, the defense counsel believe his client is currently incompetent. The court will order an evaluation. Are you requesting the court to have a doctor evaluate him, or do you have someone that you're going to have evaluate him?
No, I have the court evaluating him, Your Honor.
All right, Ms. Ferguson. Can you let magistrate's court know that we need an expedited competency evaluation for Mr. Torres?
Yes.
And what date will we come back? Yes, and tell them if they can expedite it, because this has been waiting for sentencing since April 3rd. All right, thank you. All right, if you all will step back, do not leave the courtroom. She will give me a date.
Yes, Your Honor, on the motion to withdraw the plea on it, was it denied or granted?
Well, I think the proper steps are, you believe your client is incompetent.
Yes, Your Honor.
You just called him to testify thinking that he's incompetent.
Yes, Your Honor.
So the proper steps would be for him, if you think he's incompetent, for us to determine if he's incompetent or not competent, because someone who's incompetent can't give testimony.
Okay.
So the proper step would be to have him evaluated for competency. And then if you would like, the court will rehear your request that he be allowed to withdraw his plea.
Yes, Your Honor.
Okay,
Thank you.
so sure, if you have a seat, we'll come back with a date for you.
Thank
you. Welcome. Yes.
So you can just wait. And maybe talk about it.
All right, for the party on Mr. Torres, where did he go to? Hi, they're gonna have a doctor to evaluate him today, possibly, so just have a seat. And we may be able to pick up things this afternoon, so just give us a moment. Who's here on Fräulein Guzman? All right. All right, so in this case, there's some issue with the feds, correct? It says awaiting to be picked up by federal government, has U.S. Marshal hold.
I believe so, Judge. He was not brought over.
All right, so I think he may have been picked up. Ms. Ferguson. Do you know if Guzman Velasquez has been picked up by the feds?
My understanding, Judge, is that
They
the
weren't
feds are not going to be prosecuting and the state will be proceeding on their cases.
Okay, all right. Do you have all the discovery?
So Judge, that was the issue. There's about 1,200 pieces of discovery on e-discovery, so it may be too large. The Fed has been unable to access it, so I did tell him if he gave me a hard drive, I'd be able to just upload it and give it right back to him pretty
All
soon.
right. So when are you going to be able to get them the hard drive?
This week, Judge.
All right, Ms. Ferguson, can I have a 30-day reset on Guzman Velasquez? All right, we're going to come back on July 6th.
Thank you, Judge.
All right.
Yes.
Jason? Hi. On this case, the defendant is deceased and they're waiting for the certificate.
Is it on our docket today?
Yes.
Let me just grab it.
Okay, sure. You're welcome. Who's here on Donald Gilliland? And where's Donald Gilliland?
Making his way over here.
Okay. All right, are you all ready to proceed?
Yes, Judge.
And have you all conferred with probation?
Not with probation, but we were to be following the recommendations.
All right, probation, this is Donald Joe Gilliland. State and defense are saying that they're going to be seeking to follow the recommendation of probation. All right. Court is calling 2020 CR 4853 and 2022 CR 0067A, State of Texas versus Donald Joe Gilliland. Can I have parties announced for the record for the state?
Daniel Escobar from the state of Texas.
Defense,
Jose Rocha, Your Honor. from
are you Mr. Gilliland?
Yes,
And each of the cause numbers, I'm showing you what's entitled motion to revoke community supervision. Did you review those documents with your attorney? Did you understand them?
Yes, Your Honor.
And cause number 2022 CR 0067A, are you the same Donald Joe Gilliland Jr., who was placed on probation for fraudulent use or possession of identifying information, 50 or more items on December 16, 2022 for a term of 6 years? And are you the same Donald Joe Gilliland Jr., who was placed on community supervision in 2020 CR 4853 for the offense of fraudulent use or possessing identifying information 10 or more elderly on December 16, 2022 for a term of 6 years? Is that you?
Yes, Your Honor.
All right, state.
In both cases, violated condition number 4 in Bexar County, Texas, the defendant Donald Joe Gilliland Jr. did then and there fail to report to the supervision officer as directed for the months of January and February of 2023 in violation of condition number 4.
How do you plead to that in each motion? True or not true?
True.
State.
Your Honor, state waives all other violations.
No objections, Your Honor.
Did you understand by pleading true to violation of condition number 4 and cause number 2022 CR 0067A? The court could find it true, grant the motion, and sentence you to 6 years in prison.
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 4? Court is finding violation of condition number 4 true. Did you understand by pleading true to violation of condition number 4 and cause number 2020 CR 4853? The court could find it true, grant the motion, and sentence you up to 6 years in prison. Knowing that, do you still wish to plead true to violation of condition number 4 in that cause number? Court will find violation of condition number true and that cause number as well. Is there an agreement?
Yes, Your Honor, it's to deny the motion, but to alter and amend conditions for a 60-day jail sanction. Bi-weekly drug testing and after that for 90 days, random thereafter. You must verify employment and residency within 30 days of release and continue with field visits 2 times per month as originally ordered.
And that's our understanding here.
All right, why should I follow that agreement? He's not reporting. Why are you not reporting? Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, I do.
You can lower your hand. State your name for the record.
Donald Bellamy Jr.
Why are you not reporting?
I had a problem and I was told that.
Your Honor, he had a
Yes,
domestic problem with who he was living with that kept him from being able to get all of the documentations and being able to keep up with.
No, he
all of
just
the
needed to go to
requirements.
probation and report.
And he understands that now, Your Honor, and that's why he's asking for this court to allow him to be able to prove to this court that he'll be able to follow all these amended conditions.
I mean, the thing is, though, he's proven that he can't. So I don't understand why I should follow conditions for someone who didn't do the basic thing, which was report. And I know I tell everybody in this court, if there's an issue with communication with your probation officer, we are always here to maybe help smooth the roads to communication. But he didn't report for 2 months. So what was he doing?
Your Honor, he was homeless. Going from one place to another, Your Honor.
That still doesn't explain why he's not reporting. And the fact that his charges are what they are, that's not good to not be reporting. So basically, he has done nothing. Has he done anything on probation other than not report?
No, Your Honor.
So he's done nothing. So we're back to why should I follow this agreement?
Because I'm relying on myself to do what I need to do instead of others. I was relying on my girlfriend and she told me basically that I wasn't on there, that if I showed up, they'd arrest me, and so I didn't
That makes
show
no
up.
sense. You were supposed to report.
And I was going to break up with them. And she
No, you
did-
were supposed to report in January and you did not report. So what do you mean about this nonsense that if you reported in January, you would be arrested? I don't understand.
That's what I was told. That's what I was told. I mean, I should have followed up myself, but I didn't with my anxiety and my VA. I was trying to follow up with that at the same time. And I didn't. Now I'm gonna take responsibility for myself and get to stay on my meds and get the VA done and do everything.
I'm not going to follow your agreement. I mean, you had your chance. You were here, you were supposed to report and you did not. I mean, that's the easiest thing to do. You haven't done anything.
I was told by that, she said the police showed up several times and I was supposed to report and they were gonna do a walkthrough, so I was waiting for them to come up with the money to do a walkthrough with my girlfriend. And I listened to her. I didn't know anything about the systems and she did, so I trusted her. And now I need to trust myself and do it myself.
Well, I mean, you knew enough about the system to have 50 plus items that are not yours. All right, the court is going to grant the motion. The court is going to revoke you. Court is going to sentence you to the minimum, which is 5 years, TDC. Give you credit for any time served. And I'm going to sentence you to 5 years in each case. The cause numbers will run concurrent with each other. And was there any restitution? Did anyone ever give notice of restitution? Because I know restitution was asked for, but I don't see where. No problem. All right, that will be the court sentence in each cause number. In each cause number, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it?
Can you speak louder?
Yes.
So she can-
All right. You do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on probation. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. Jose Ramirez?
Have you excused your?
Yes, thank you.
Yes.
Okay. All right. Can I see the partiers on Taurus, please? Yes. Yes.
Oh, there's no audio?
And if you could write that in there. for me,
5
please.
years.
Hi, Ms. Ferguson is going to give you a reset form for when you can appear.
Yes, Your
Oh,
And counsel on Taurus.
Yeah.
They have an appointment scheduled for him for next week.
okay,
And so after he finishes that, we'll bring him back up here.
okay, sounds good.
All right. And I'm sorry, who's next?
It was, I think you called it Ramirez.
Let me find it. Jose Ramirez? Where's Mr. Ramirez? Come down. All right, so we are back here for CPS records. A video, there's an issue with the audio. And the state was to speak with the complaining witness. So where are we?
So I did speak with the complaining witness, the mom this morning, and I am prepared to give an offer. As far as the other issues, I don't think we've resolved the audio issue yet, Your Honor.
All right, so what's the issue with the audio? When is that going to be resolved and why is it not resolved?
I don't know, Judge. It just said that, I mean, they know that it doesn't have, it seems it doesn't have any audio.
So
All right, so was there?
I'll pull it up, Your Honor, and see if maybe it's. And like, because sometimes with e-discovery, it can.
Yeah, I
Convert
mean,
weird,
it's there
so
from the
I-
notes from the prosecutors. I haven't seen it yet because I was expecting them to tell me that it was okay for me to see it.
Okay,
So far, as soon as she emailed me or something, I could manage to go and see it, but it seems that the issue is still on.
And I personally hadn't conferred with him, but I am prepared to give an offer today.
all right. So Ms. Ferguson, can I have a 30-day reset on Jose Ramirez for discovery?
Which could we be a little bit shorter? Because our client has been in jail for 60 days now, and we believe that that's a good case, so maybe 3 weeks could be.
All right, well, what I'll do, counsel, is I'll put it on July 6th. And if you all want to come back sooner and you have everything sooner, then you can always come back before.
Appreciate it.
All right, thank you. All right, we'll see you then. Demetric Jackson. Juan Ratana. Who's here on Juan Ratana?
Yeah.
Okay, thank you. Hello. Who is the prosecutor on Juan Ratana?
Yes, sir.
Thank you. Court is calling 2022 CR 3725C, State of Texas versus Juan Carlos Ratana. Can I have parties announced for the record for the state?
Ruben Herrera for the state.
Defense,
Joe Stenberg.
counsel. Mr. Robertson? Hi, if you could not talk behind the court reporter, we're on the record. No problem. Yes. And are you Mr. Juan Ratana?
Yes, ma'am.
All right, counsel, have you received all the discovery? Did you review it with your client?
I did.
Court will find that the state is in compliance with discovery. Mr. Ratana, I'm showing you what's entitled application for deferred adjudication. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Mr. Ratana, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it and did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with the offense of aggravated robbery? That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to $10,000 fine. Did you understand if you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement? If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to life in prison and up to $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses? Counsel,
Yes.
do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Do, Your Honor.
Mr. Ratana, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Honor.
Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, there's an affirmative finding of deadly weapons. State recommends deferred adjudication. They will take in consideration 2022 CR 3726C. There's to be no contact with Margie, Claudio, or Renee Patino, and there's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition? If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
Did you understand with an affirmative finding of family violence, you're also not allowed to be designated as primary custodial parent?
Sure.
I'm sorry?
Yes, Your Honor.
Did you understand that to be the entirety of your plea bargain agreement?
Yes, Your Honor.
Defense,
Pardon me?
is that the plea bargain agreement?
Yes.
State, is that the plea bargain
Yes,
agreement?
Your Honor.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement, the state is requesting that your community supervision be for a term of 5 years. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
No,
No content. I'm sorry. I'm sorry.
State any evidence to support the defendant's no contest plea?
State offers State's Exhibit 1 and all attachments.
Any objections?
Okay.
Mr. Ratana, I'm showing you what's entitled, and state you may be excused, showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after viewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding you guilty as you apply for deferred adjudication. State,
Yes, Your Honor.
on this case, have you spoken to the complainant?
Yes, Your Honor, they're aware of the agreement.
And are they in favor of this agreement?
They are.
All right, thank you. All right, Mr. Rotano, are you employed?
Yes, ma'am.
What do you do?
I do flooring, wood floor, carpet, maybe I do wood floor.
Do you have any children?
Yes, ma'am. I have 6. One just passed away recently.
All right, what are their ages?
8, 21. I got 2 twin boys, 18, got a 8-year-old and 5-year-old
And where are the 8 and 5-year-old?
with my mother.
All right, this is what the court is going to do. Court is going to sentence you to 10 years deferred adjudication. Taking consideration 2022 CR 3726C. There's to be no contact with Margie Claudio, Renee Patino. There's an affirmative finding of family violence. There's to be restitution, if any, to Margie Claudio and Renee Patino. There is to be no contact with the following. Samantha Richards. Jacqueline Wallace.
And Your Honor, may I address that?
Yes.
Jacqueline Wallace is the mother of his 2 youngest children. And they relate to each other about raising their children. In fact, my client's mother is raising all the remaining children.
She
And
probably should be.
pardon me?
I think she probably should be, because I don't think at this point in his life, he would be a good influence.
Well, you may recall Jacqueline Wallace was a co-defendant.
Yes.
Okay. And she comes and visits the children and
All right, then you all would have to make that arrangements with the grandmother, but you're not gonna have any contact with Jacqueline Wallace. Because what I have before me now is you all are committing offenses together. So you're not to have any contact with her, you understand?
Yes, ma'am.
All right, 200 hours community service restitution. We'll do parenting classes with rainbows. There's to be regular UAs. Is there a drug issue?
No.
Regular UAs, regular reporting by Zoom or in person. And I'm notating that you said that there are no drug issues, so you should not come up positive. You understand?
Yes, ma'am.
And I'm writing that on the docketing sheet. So regular reporting by Zoom or in person, proof of employment within 30 days of release. There's to be no employment as a home healthcare provider or with minors. Is Child Protective Services involved?
No, ma'am.
I'm gonna want field visits. One time per month until further notice. Anger management classes. Probation, is there anything else he needs?
No, Your Honor.
Is there any,
I apologize. Are you?
200 hours community service hours? He's gonna do the parenting class. Once he's completed that, the community service hours will be deemed to be satisfied.
One question, I have
Yes.
a certificate for parenting that I
When was that done?
in Bear County,
No, when?
about like 2 months ago. I had a certificate for parenting classes and domestic violence classes.
So why did you do that?
They just gave me those programs. when I was
Oh, at
there.
the jail?
Yes, ma'am.
Okay, all right, just
I got
provide,
the certificates.
provide proof of that, okay?
Okay.
All right. Is there anything else you need from the court?
No, ma'am.
All right, I'm going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Oh, Mr. Bauer, since you're standing there.
I would glad judge it, it'd be my pleasure.
Thank you. Because this is I'm sorry, and there's also an affirmative finding of a deadly weapon. All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. You understand?
Yes, ma'am.
Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, from here, we're off the record. From here on out, everything you do in your life, you need to ask yourself, is this something that could result in me going to prison for life? If the answer is yes, don't do it. If the answer is maybe, do not do it. Do you understand? All right, in this court, in order to be successful, communication is key. So if you have any issues, speak with probation. If you feel like they're not addressing it, then you can approach the court. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
All right.
thank you. Your Honor.
Would you approach very quickly? I got a plea bargain worked out on my case, but I need to see if I can do it tomorrow. I have an appointment this afternoon. I have an appointment.
Oh,
The files up there. We gave you files just.
Yeah, Jesus Martinez came too.
okay. All right, so when will you be prepared for?
I can do the plea tomorrow morning. If they get the paperwork ready.
All right. So this afternoon,
No, I have an appointment this afternoon. I want to see if I can do it tomorrow morning. I'll be here at 9.
we can't get it done now.
I just got it worked out.
Okay. All right, Ms. Ferguson, on,
I want to do it tomorrow.
no, because tomorrow is Friday and we have a trial on schedule.
I can do Monday or Tuesday or whatever day y'all want.
All right, and I do see where you need to be.
Yes, but
with the other judge.
Mhm.
All right, so you let the other judge know that I'm allowing you to come back on Monday.
Thank you.
All right.
I
Ms.
thought you
Ferguson.
called me so I can avoid it.
Ms. Ferguson. All right. Just 1 second.
No, not that. Martina Santos.
All right, Mr. Bauer, can I see you for a moment? Yes. So you'll give his client a reset form. Mr. Merrill, we're gonna give your client a reset form. Is he in custody?
Oh, yeah. Oh, yes, he's a guest.
Okay. We'll see you.
I'll be here.
Thank you. Tony Segura.
Judge, he's not here this morning. I wanted to let the court know that he called me yesterday that he tested positive for COVID. I asked him to send me proof, which I have with me, so we could just have a reset long enough for him not to be contagious.
All right, Ms. Ferguson. Mr. Segura, we need a reset date. He's positive. Well. Just 1 moment, Ms. Ferguson, on that. All right, this is from Wednesday, May 31st. So when should we bring him back? COVID. Yeah.
So we usually give you like 5 days.
All right, so he was positive on May 31st. When do you want to bring him back? All right, we'll come back on June 8th. If you'll let him know. Who's here on Armando Rodriguez?
Robert Gallon, the judge, you're ready.
All right. Probation, this is an application.
Thank you, Honor.
Court is calling 2022 CR 10589. State of Texas versus Armando Rodriguez. Could I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense.
Robert Gallon.
And are you Mr. Rodriguez?
Yes, ma'am.
Counsel, have you received all the discovery in this case?
Yes, Your Honor.
Review with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Rodriguez, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, we do, Judge.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Mr. Rodriguez, I'm showing you what's entitled court admonishments. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with theft under $2,500 enhanced at the state jail felony? Range of punishment is up to 180 days. I'm sorry, anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand? You need to speak up.
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to $10,000 fine? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Mr. Rodriguez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand that?
Yes, ma'am.
According to the plea, there's a $1,500 fine. State recommends deferred adjudication. They're taking in consideration night mag number 7099933. Did you understand that to be the plea? Defense?
We did, Your Honor. There's no opposition. We were asking that you consider probating some of the fine.
All right. State, is that the agreement?
It is not all of it.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's plea?
Yes, Your Honor. State Exhibit number 1 with all of its attachments.
Any objection?
No objection.
All right, state, you may be excused.
Thank you.
Did you review the document entitled waiving consent to stipulation of testimony and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court would defer finding of guilt as you apply for deferred adjudication. Are we proceeding with sentencing?
Would ask that the court proceed with sentencing, Judge.
Anything you wish to say on behalf of your client?
Judge, he's been down on his luck. He's very, seems very easy talking gentleman, and I was able to confer with him quite well. He just admits that he had hard times and kind of evident as to what the evidence shows. I want to ask the court for a break and follow that plea bargain.
All right, it seems like he's been having a lot of hard time because we're constantly here for him stealing. So why are you continuing to steal?
I've been working and trying to get something to eat and homeless.
That doesn't mean stealing a bracelet. I can understand you went to HEB and took food, but I don't understand you're stealing from Marshalls and all of these other places. So what's going to be different?
Just some try to change my ways.
I mean, how are you planning on doing that though? Because so far you just keep stealing. So you're stealing in 2019 of January, August 2019, and here we are in 2022, you're stealing again. So what are your plans?
Well, summer's coming and I'm planning to get a job now.
Why haven't you gotten a job before?
Because I was gonna do like landscaping and it slows down a lot during winter.
Were you doing landscaping in 2019?
No, sir. No, ma'am.
So here's your choice. I can give you deferred adjudication. In this court, I require that everyone have employment, not you're going to get employment, but you actually have employment. Or if you want, I will send you to the state jail facility, and I will send you to the state jail facility for a year. And you can sit at the state jail facility for a year and think about what your future plans are going to be. Or if you want, I will give you 3 years deferred adjudication, but if you are unsuccessful, you're looking at 2 years potentially. What would you like to do? Well, I mean, your attorney is saying you want probation, but here's the thing, what I always tell people, your attorney is not going to be doing probation. If your attorney were doing probation, I would say there's a 99% chance he will be successful at it.
99.
Yeah, well, 99.999%. You never know, something may happen. You may win the lottery and say, I'm not reporting, I'm gonna go travel. So, do you want the 1 year at the state jail facility, or do you want to try your hands at deferred? Okay. This is what the court is gonna do. Court is gonna sentence you to 3 years deferred adjudication. There's a $1,500 fine that will be probated. Take in consideration NIGHTMAG number 709933. There's going to be 120 hours community service restitution. Do you have any children? All right, there's to be no contact with Home Depot or Marshalls. There's to be regular reporting by Zoom or in person, regular UAs. Are there any drug issues with you?
Excuse me.
Are there any drug issues with you? Where's your family?
I have lost contact for a while now and I really don't know.
How do you lose contact with your family? Why are they not concerned about you or looking for you?
They moved on, my mom passed on and we just went separate ways.
All right, proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. And we're going to do cats 1 and 2. Their theft course. Probation, is there anything else he needs? Is there anything else you need from the court to be successful? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it? Because this is a plea bargaining agreement, because I call it your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, good luck to you.
Thank you, Judge.
Who's here on Yusiro Mesa? All right. Have you all conferred with probation?
Yes, we have, Your Honor.
All right, the court is calling 2022 CR 1397, State of Texas versus Yusiro Mesa. Could I have parties announced for the record for the state?
Casey Garahan, Your Honor.
Defense?
Michael Goins for the defendant, Your Honor.
Are you Mr. Mesa?
Yes, ma'am.
Showing you what's entitled motion to revoke community supervision and First Amendment motion to revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Yusiro Mesa who was placed on?
Regular probation, Your Honor.
Oh, yes, I see now. Just a second. Thank you. Placed on community supervision in 2022 CR 1397 for the offense of aggravated assault, serious bodily injury on April 5th, 2022 for a term of 5 years. Is that you?
Yes, ma'am.
State?
Yes, Your Honor. Violating condition number 1 on or about the 26th day of March 2023 in Bexar County, Texas, the defendant Yusiro Sebastian Mesa committed the offense of deadly conduct firearm in violation of condition number 1.
How do you plead to that? True or not true?
Your Honor, we'll waive the remaining violating.
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion and sentence you up to 8 years in prison and up to a $1,500 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there an agreement?
Yes, there is, Your Honor. And that is revocation of the defendant office probation as its alternate amendment is underlined to 7 years in TBC.
Is that the agreement?
It is, Your Honor.
I'm
Mr.
Sorry, Your Honor, to interrupt you, but also the statement of taking consideration CM number 108277, which is the deadly conduct he pled true to. Then also Night Mag 710141, a felon in possession of a firearm.
All right, is that the agreement?
It is, Your Honor.
Are you asking the court to follow that agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right, then the court will follow your agreement, grant the motion. Court will sentence you to 7 years in the prison. Taking consideration CM 108277, Night Mag number 710141. And there's to be no contact with Ronaldo Molina and Layla Molina. Probation, was there any restitution?
Your Honor, no restitution as well.
I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
We can go off the record. How old are you?
28.
You're gonna have to change your ways. Otherwise, you're gonna find yourself living at somebody's prison. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
You're welcome.
Your Honor, may I be excused?
Yes,
Thank you, ma'am.
you're welcome. Who's here on Christopher Anthony? And probation, there's no application.
Thank you.
Morning, Your Honor.
Give me the document sheets. It should be in there, I think. All right, court is calling 2023 CR 1645, State of Texas versus Christopher Anthony. Could our parties announce for the record for the state?
Jason Garrett, Your Honor.
Defense,
Christian Bigger for the defense.
are you Christopher Anthony?
Yes.
Counsel, have you received all the discovery and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Anthony, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Going to show you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with the offense of possession of a controlled substance, penalty group 1 less than 1 gram? That is a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargaining agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Anthony, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, no.
Has anyone promised you anything other than the plea?
No, Your Honor.
Counsel, excuse me. No talking while we're on the record behind the court reporter. If there's room, you can move to the other side. Did you understand by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Anthony, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, Your
Are
Honor.
you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 15 days in the Bexar County Jail under 1244, and there are no applications. Did you understand that to be the plea?
Yes, Your Honor.
And did you understand with that plea that will still result in this being a felony conviction?
Yes, Your Honor.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
It is, Your Honor.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offense is charged, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence?
Yes, Your Honor. State exhibit number 1 with all its attachments.
Any objection?
No objection, Your Honor.
State, you may be excused. Showing you the waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to a jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor. He has 15 days.
All right, anything you wish to say on behalf of your client?
No, Your Honor.
All right, the court will sentence you to 15 years, right? 15 days trying to see if everybody's still awake.
I was like,
The
oh,
court will sentence you to 15 days in the Bexar County Jail under 1244. Give you credit for any time served. The court will show that the judgment is satisfied. Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it and did you sign it?
yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Mr. Anthony, if you have a drug problem, you need to get help for it.
Oh, yeah, it was just, it was a bad situation.
I'm just letting you know.
Yes, ma'am.
When I was growing up, they used to have a cartoon about drugs rotting your brain. Drugs will rot your brain.
They
You understand?
definitely would. Definitely. I have 3 jobs now. I'm not clean, so.
All right. Good luck to you, okay? All right, have a great day.
Thank you, Your Honor. You too.
All right, and I'll check this. Okay, I was like, oh. All right, could I see the defense attorney on Demetric Jackson? All right. Okay, well. Glenny Hernandez. All right. I'd like number 2. All right, Glenny Hernandez.
Good morning, Your Honor.
Where's the
All right, good afternoon.
defendant?
He's in the bottom.
All right, have you all conferred with probation?
We had an agreement on this matter.
All right. Court is calling 2020 CR 11194, State of Texas versus Glenny Hernandez. Can I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Defense?
Eric Hernandez for the defendant, Glenny Hernandez, no relation.
Okay. Are you Glenny Hernandez?
Yes, ma'am.
Showing you what's entitled motion to revoke community supervision and first dependent motion to revoke community supervision. Did you review those documents with your attorney? Did you understand them?
Yes, ma'am.
Are you the same Glenny Hernandez who was placed on community supervision and cause number 2020 CR 11194 for the offense of assault family second on March 29, 2021 for a term of 4 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor. Yes, violated condition number one, on or about the 20th day of April 2023 in Bear County, Texas, the defendant Lenny Hernandez Jr. committed the offense of possession of controlled substance, penalty group one, violation condition number one.
How do you plead to that? True or not true?
True.
Your Honor, we'll waive the remaining violations.
No objection, Your Honor.
All right, did you understand by pleading true to violation of condition number one, the court could find it true, grant the motion, and sentence you to 3 years in the prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number one?
Yes, ma'am.
Court will find violation of condition number one true. Is there an agreement?
Yes, there is, Your Honor.
And what is the agreement?
Is to revoke the individual office probation and sentence him to 3 years in Texas Department of Corrections.
Is that the agreement?
That is our agreement, Your Honor.
And judges, for the record, we are taking into consideration, County Court 12, clause number 707-168. Also a night bag case 709-297, and also night bag case 709-298.
All right. Thank you. Mr. Hernandez, are you asking the court to follow that agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right, the court will follow your agreement. The court is finding violation of condition number one true. The court will grant the motion, sentence you to 3 years in the prison, give you credit for any time served. There's an affirmative finding of family violence, taking consideration 707-168, night mag number 709-297, night mag number 709-298. There's to be no contact with Monica Aguilar. There's $1,000 fine, time and money to run concurrent. Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review this document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, and also because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you. Do better. You understand?
Yes, ma'am.
All right, good luck.
Thank you.
Who's here on Eric Gonzalez Lopez with the interpreter? All right, hi. Thank you, thank you. All right, it's on this one, it says, oh, we're waiting for her to put the headphone. All right, on this case, in April, we were waiting for the feds to pick up the defendant.
No, just not anymore, Judge.
Yeah.
Judge, just sorry, just to step in, but this is a 4 co-defendants. They were supposed to be picked up. My knowledge right now, the feds are not going to pick that up as of now. So the state is going to proceed on our cases.
All right, so Ms. Ferguson, what date do we give the other co-defendants? This is 10958A. All right, so we're gonna come back on July 6th for discovery compliance. All right, thank you so much for coming down. It's always great seeing you.
Yes,
Have a good one.
to be here.
Right, thank you.
187.
Thank you. Roger Salcedo.
Yes.
Morning, Your Honor.
Good morning. So today is the plea deadline date and counsel, you're on this side.
Your Honor.
If you would have been here earlier, you would have seen your wall.
I know, I was in a different place.
All right, there's no gum chewing up here.
Sorry, Mom.
All right. So today is the plea deadline date, and defense, you were to provide the state with some information.
We provided it to the state. They reviewed that information, Judge. We're still going forward with the case, and we have rejected the plea they have made to us.
All right, and is this family violence?
No.
All right, Ms. Ferguson, I need a jury trial date on Roger Salcedo, criminal trial division. How long do you expect this trial to be?
3 days, Judge.
3 days?
Yes, yes.
All right, your jury trial date will be July 18th. Do you understand?
Yes, ma'am.
All right, they'll give you a reset form, then you're excused. And Deputy Laura, I'm just trying to clear this box out a little bit, so you won't have to bring people back out. All right,
Thank you, Your Honor.
sign the reset form, you're excused. Who's here on Ruben Gonzalez?
I am, Your Honor.
All right, where's your client?
That's what I'm asking. I asked the deputy, she said he answered, but I don't see him anywhere around.
Ruben Xavier Gonzalez. All right, you need to get him back here by 1:30.
The guy is homeless. I'm trying to get a hold of him.
All right, thank you. He didn't answer? Oh, he
I
didn't
thought you
answer.
said he did answer. My mistake.
All right, so counsel, I will give you till 1:30. Who's here on Christopher Gibbons?
Yeah.
Well, who is it, Salcedo?
No, I have Randy Benitez Lopez.
Yeah, if you'll give him the same date, would you like to say? Okay.
Yes, sir.
Thank
Thank you. I heard I've got to get the discovery thing taken care
All
of.
right, thank you.
But they didn't even bring him good.
Okay,
Thank you.
all right, so what is happening on this case? I see, we pled no contest to count one. And then, there's supposed to be a PSI and a TAP, the warrant was issued by Judge Angelini.
Looks like a judge of indication. This counsel, please tell me if I'm wrong. He did get picked up for failure ID at some point.
He missed court on the original court date, Your Honor. The stuff for the TAP evaluation hadn't been done yet. And so then a warrant was issued. He was picked up on the 23rd. And all the evaluations got done at that point.
All right, so are you proceeding with the same plea offer?
To determine what that same thing offer here. I'm sorry.
Oh, it was supposed to be, punishment to be assessed at 6 years in the prison. The state was recommending community supervision.
Sorry, Greg, I didn't know that was the offer.
Yeah, no
I
problem.
need to step back for a second.
Sure.
Thank you. Judge,
Yes.
Ruben Gonzalez. I got a message left on the answering service. He's telling me that he couldn't make it today. He got jumped last night. He was going to the hospital.
Oh, well, then he needs to provide medical proof to you. So 1:30. Medical proof. If he doesn't have medical proof, a warrant may be issued.
Okay.
Deputy Laura. Deputy Mejia, would it be difficult to just have them wait back there real quick while we check the verdict?
Sorry.
Okay, all right, thank you. Okay. Okay. All right. Yeah. All right, after we take this verdict, you can take a break. All right, everyone, we have a verdict on this trial that's in, so we're gonna take the verdict, but do not disappear because it's gonna be quick. Okay. And where is Luis Martinez? All right, thank you. Then I'll take up, because she's gonna take a break, and then I'll take up the compliance hearings after this verdict. And Deputy Laura, depending on what the verdict is, we may send them on a lunch break and then we'll come back.
I do that every day.
Oh, I don't have a file on it. You don't have a file on it. Usually in Ramirez, it's the compliance. Oh, you know what? It's Beasley Magallanes. Okay. All right, a lot of people always think, and I know I always thought that the judge knew what the verdict was before the verdict came. I have no idea what the verdict is, so whatever the verdict is, I don't want any outbursts from anyone. So that's where we are. We're ready.
All right, for the jury.
All right, everyone, please be seated. All right, ladies and gentlemen, it's the court's understanding that you've reached a verdict. Is that correct? You all are very quiet and speaking very softly. Is it unanimous?
Yes.
All right, thank you. All right, if you'll pass the verdict to the deputy, please. Thank you. All right, if the defendant will please rise. All right, it states, we, the jury, find the defendant, Courtney Care Pride, not guilty. All right, would anyone ask that the jury be polled?
Not from state judge.
No, Your Honor.
All right, thank you. You may be seated. Ladies and gentlemen, I'm going to send you back to the jury room and then I'll come back and speak with you, okay? All right, thank you very much. Everyone, please rise for the jurors. And we're still in the record. All right. So, Ms. Pride, excuse me. Hi, everyone, please be seated. All right, Ms. Pride, you do have the right to have this case expunged, but you have a limited amount of time to do that in. Do you understand? All right. Anything else from defense of the state?
No, Judge.
All right, thank you. And everyone, I'm going to give the court reporter a short break because she's been typing down everything that everyone's been saying for 4 hours. So everyone, do not leave. She's going to take a break and we'll be right back. Rita Gomez.
That's mine. Ready.
Okay. And then after that, it's going to be Edward Ramirez and Tamia Beasley. All right, did you all confer with probation? Hi.
Hi.
Mr. Garcia, are you all ready?
Yes.
Did you all confer with probation?
Yes.
All right, court is calling 2021 CR 6154, State of Texas versus Rita Gomez. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Judge Richard Garcia for the defense, ready?
And are you Ms. Gomez?
Yes, ma'am.
Showing you what's entitled motion to enter adjudication of guilt and revoke community supervision and First Amendment motion to enter adjudication of guilt and revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes.
Was this a transfer off the record? It's 2021 CR 6154.
Right.
Ah, okay, thank you. That explains it because I saw Judge Stahl's name on this. All right, we're back on the record. Are you the same Rita Nina Gomez who is placed on deferred adjudication in 2021 CR 6154 for the offense of possession of a controlled substance, penalty group 1 gram to 4 grams on March 15, 2022 for a period of 2 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 4 in Bexar County, Texas. The defendant, Rita Nina Gomez, did then and there fail to report to the supervision officer as directed for the months of December 2022 and January 2023.
How do you plead to that? True or not true?
True.
State waives all the violations.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to $10,000 fine? I'm sorry?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there an agreement?
Yes, Your Honor, it's to deny, to extend supervision for 1 year and alter and amend for safety, and the defendant is to wait in jail for a bit.
All right. Are you asking the court to follow this agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes.
All right, the court denied the motion, alter and amend conditions to include safety. Do you have any, does she have any violent offenses in her past?
Not that I don't recall seeing any violent. It wasn't in the PO report.
I don't see anything good.
All right, this is what the court is going to do. The court will deny the motion, alter and amend conditions to include, we're going to do a referral to felony. I'm sorry. Yes.
Your Honor, let me look it up. She was already referred to felony drug court, and I believe. What's the outcome?
Okay. So I'm wondering if they said refer her to Esperanza Court instead.
She was in Esperanza Court, Judge.
Okay.
Is there a way I can go drug court instead?
Well, let me just tell you, you should have done what you were supposed to do in Esperanza Court.
And the other part of the agreement, judges, that I forgot to tell you that they're TIC too.
Sure.
Give me 1 second, and I'm gonna bring you this information.
Okay.
I think we could probably refer at this point.
Mhm.
This was the last conversations we were having.
Okay, all right, thank you. All right, so this is what the court is going to do. The court will deny the motion, alternate amend conditions to include a referral to felony drug court and a referral to safety. And Ms. Abrams, can you let them know that she was unsuccessful in Esperanza Court? And she's to remain in custody until evaluation and acceptance. Is there anything else from either side?
Other from say.
Thank you, Judge.
All right, thank you.
Thank you.
All right. Edward Ramirez.
Your Honor, Mr. Ramirez was in the audience. He submitted a positive UA and he's no longer here.
All right.
I'll check outside to make sure he's not present.
Okay.
Ma'am.
All right. Then with regards to Mr. Ramirez, I know I said schedule a compliance hearing, file a motion to revoke.
Yes, Your Honor. Make a motion. No, you're the right spot.
Camilla Beasley.
Ibanez. Ibanez.
All right. So, Miss Beasley, do you have any children living with you? All right, and who is that?
Royalty, she's not fired.
All right. So, I'm not going to allow you to live with Mr. Williams because he has issues of his own. You understand?
Yes, ma'am. I don't, and I wanted to let you know, we're not together no more, nothing like that is going on.
When did that, you need to speak up. When did that end?
I would say about a month ago.
Because you were just here with us by Zoom, were you not?
Yes, ma'am.
And when was that?
Thursday.
Thursday. So who are you living with?
No, we are in my apartment. That's where we are at in Austin.
And who lives in the apartment with you?
Me and Royalty, he doesn't stay there anymore. He's back in San Antonio.
No, that's not what you said on the Zoom. I will tell you, my mind is a steel trap. I remember you being on Zoom and I remember you saying that you lived there with him. And my issue was that you all were jumping from place to place to place.
Yes, sir. So we were living with him at first in San Antonio. Then we moved to Austin. I stayed in Austin. He left back to San Antonio.
Deputy Laura, can you look this cause number up and tell me if he is in custody? It's 2018 CR 12116. Oh, no problem. Jamarkese, Jamarkese Williams. Or I guess it's Jamarcus.
Talking in the box. I don't see his picture.
All right, so he's not here in Bear County, because if he was, there's a warrant for his arrest and he would be here. So he's not here.
He's not with me,
Yeah.
so I don't.
All right. So you need to come back to Bear County
Yes.
because you're not in a stable situation and you're not even stable where you are because you say the lease is not even in your name because of your issues. So you need to come back to Bear County. You understand? All right. Bashan,
Yes, Your Honor.
on this case, I'm giving her 14 days to get back to Bear County. Do you understand?
Yes, ma'am.
And you are not allowed to move anywhere else without my permission. So if there isn't something on your paperwork that says Judge Boyd is giving you permission to move, you are not to. Do you understand? All right, so. So she needs to be back. I'm going to give her till June 20th. So I'm giving you more than 14 days. So you're coming back here by that time. Do you understand?
Yes, ma'am.
And I'm going to explain something to you. I know sometimes people say, Judge, it's not your business that I'm moving all over the place and taking my child everywhere, but it is. And the problem is people don't understand that children are people too. And part of my job when I take, people and place them on probation is to protect the community. And for some reason, people think protecting the community doesn't include children, that children have no rights and they should just go on their merry way on whatever adventures or misadventures their parents are taking them. So if you look at it objectively, your daughter has been taken from place to place to place. And Mr. Williams, he's not her biological father, is he? So I want you to think about how many men or how many adults you've brought into your daughter's life that shouldn't be there. He is on probation for assault, bodily injury out of a felony court. And that's who you brought into your daughter's life. I don't know why people don't do background on people when they have children. You should stop bringing random people into your child's life. You understand? Probation, is there anything else that she needs?
Your Honor, she completed a parenting program that was for a 4-hour course. Is that acceptable in court's eyes?
What did you learn from that course?
Well, I took it in 2022. I passed everything I remember. Basics as far as how you should treat your child and how to cope with things with your child, how to act around your child, what not to do around your child.
How not to bring inappropriate people around your child, which is what you did. She needs an updated course of parenting, a remedial course in parenting. So if there's another course for her to take, and it doesn't have to be the complete long course, but obviously she didn't get the point that you're not supposed to just allow random people around your child. So is there a course?
I'll look
Should we
into
try
it.
rainbows?
I'll talk to the CSO to see what we come up with, Your Honor.
Okay.
But as far as alternate amending conditions, is it okay that I just put a parenting course?
Yes.
And then
And if you are not by care by June 20th, what's going to end up happening is a warrant may be issued for your arrest. You understand?
I do want to point out, Your Honor, that her intensive outpatient treatment begins on the 12th of this month. So, and that will be in person as
Okay.
well.
Okay.
Here.
All right. And can you make sure that they do field visits?
Yes, Your Honor. How many times a month?
Let's start off with 1 time per month until she has at least been in outpatient treatment for at least 2 months. And if probation doesn't see any issues at the home, they can then do field visits as they deem necessary. Now, is there anything else you need? And how old is your child? All right, so let me explain something to you. She is 100% dependent on you to protect her, to bring good people into her life. You understand? You can't come first anymore. It has to be her because she cannot get a job on her own. She cannot take care of herself. She can't enter into contracts where she gets apartments on her own and any of that. She's dependent on you. You understand? All right. Is there anything else you need from me? You sure? All right. So in this court probation, to be successful, you got to communicate. If there's something going on in your life that you need help with, contact probation. If you feel they're not addressing that issue, then you can come to court. Okay? All right. Good luck to you. Who's here on Daniel Ortiz? Oh, I'm doing great. All right, this is no application.
No,
Yeah. Court is calling 2022 CR. Council, decide. 5307, State of Texas versus Daniel Ortiz. Could I have parties announced for the record for the state?
Daniel Escobar from the state of Texas.
Defense?
Ed Cano.
And are you Mr. Ortiz? Counsel, have you received all the discovery? Did you review it with your client?
Yes, ma'am.
Court will find that the state is in compliance with discovery, showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
Please, an indictment.
It's,
Please, an indictment.
it appears that you're proceeding on the repeater.
Yes.
Any objection?
No objection.
Mr. Ortiz, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of possession of a controlled substance, penalty group 1 gram to 4 grams? If the state proves the repeat offender enhancement allegation, your range of punishment will be anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to a jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights? Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Ortiz, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, punishments be assessed at 4 years in the prison. You agree that you've been previously convicted of a felony for enhancement purposes. There are no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, ma'am.
State, is that the plea?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Did you understand by signing that you're giving up your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions? Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
Guilty.
And to the enhancement allegation to the cause number that ends in 2000 CR 54318, how do you plead? True or not true?
True.
State any evidence?
State officer states to one in all facets.
No objection.
You may be excused. Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty. The court will find you guilty. Court will find the enhancement allegation true based upon your plea of true and based upon states exhibits 1 and attachments. So you're proceeding with sentencing?
Please, Judge.
Anything you wish to say on behalf of your client?
No, not at this time.
All right, the court will sentence you to 4 years in the prison, give you credit for any time served. Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? And did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. We can go off the record. You're gonna have to make better decisions, okay?
Thank you.
All right, good luck. Ms. Ferguson, Benitez Lopez, what date did we give all the co-defendants? All right, so that's gonna be recalled for July 6th. Who's here on Jonathan Bolden? Have y'all conferred with the probation?
Yes, sir.
All right, court is calling 2022 CR 11444, State of Texas versus Jonathan Bolden. Could I have parties announced for the record for the state?
Travis Banks in the state of Texas.
Defense?
James Merritt for defendant Travis.
Are you Jonathan Bolden?
Yes.
Showing you what's entitled motion to revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes.
Are you the same Jonathan Bolden who was placed on community supervision in 2022 CR 11444 for violation of sex offender registration on April 3rd, 2023 for a term of 5 years? Is that you?
Yeah.
That's either yes or no.
Yes.
All right, state.
Violated condition number 8B in Bexar County, Texas. The defendant, Jonathan Bolden, did then and there fail to report to the supervision officer as directed after being released from jail in violation of condition number 8.
How do you plead to that? True or not true?
True.
State.
And the state will waive and abandon the other.
Any objection?
None.
Did you understand by pleading true to violation 8B, the court could find it true, grant the motion, sentence you to 2 years in the prison?
Yes.
Knowing that, do you still wish to plead true to violation 8B? Is there an agreement?
Mr. Honor, the agreement is to deny the motion and continue the defendant on probation and alter and amend the conditions for a 30-day jail sanction. Give him credit for time served, and I think he should have enough time to satisfy that judgment. And further, the state is asking that the court admonish the defendant about reporting for probation, even when circumstances involving having permanent residence are making that difficult for him.
Okay, why should I follow this agreement? Because he's here for not registering. And then he's here again for not reporting.
Your Honor, yeah, so he was granted probation 2 weeks before the MTR was summoned. And so he's only been on probation hardly for 2 weeks. He got off bad at the starting blocks and hardly got on the saddle for reporting. Now, mainly the issue here is stable housing. He does not have stable housing. At this
Well, I mean, you
time.
get on a via bus or somewhere and you report, or either you call probation and say you can't report. I don't understand.
Mr. Bolden certainly has pled true for the reasons that he had trouble communicating and getting in touch with his probation officer. And I believe there was a miscommunication problem where he could not make the first reporting. I think we give him another chance to get back on the saddle, get in touch with his probation officer. Mr. Bolden will certainly make best efforts to report in person.
Probation, was there some sort of miscommunication that I'm unaware of?
Your Honor, no, not from any of my notes.
Excuse me.
Want to raise your right hand? Solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
True.
All right, you can lower your hand, state your name for the record.
Jonathan Bolden.
Yes.
I
Once I left the jail, I tried to call the probation department, which everybody told me to call. And I called on my phone when I was sitting on the bus. I didn't get no answer. I called back the next day. They said that the person, my probation officer, will get in contact with me in 2 or 3 days. And I didn't hear nothing. I called back. I have records of all the calls I made. I called back. A voicemail from a woman said, I won't be in office in 2 or 3 days. And to call back. So I waited that weekend and I called Friday. And a man answered and said that I was, he put a warrant for my arrest because I didn't contact.
All right, this is what the court will do. The court will deny the motion, alter and amend conditions for weekly reporting for 2 months. If you do not report, you're going to have another motion to revoke filed. Do you understand? Is there any confusion on what you need to do? All right, is there anything else from either side?
Nothing further from the state, Your Honor. None, Your Honor.
Probation, is there anything else he needs? All right, thank you. Who's here on Christopher Givens? All right, has everything been resolved with Mr. Givens?
I think so.
All right. Court is calling 2022 CR 6398, State of Texas versus Christopher Charles Givens. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
John Roberts for Mr. Givens.
And are you Mr. Givens?
Yes.
All right, so we are back on the record on this case. There was a warrant that was issued. And the court question was whether or not the state was still intending to follow the plea bargain agreement. So is the state intending to follow the plea bargain agreement?
So yes, Your Honor, but we would go with the PSI recommendation, I believe it was state ISM.
Okay. All right. Have both parties had a chance to review the PSI report, state and defense?
Yes, Your Honor.
Any objections to the PSI report, state?
No, Your Honor.
Defense?
No, Your Honor.
All right. Defense, did you want to address the issue of state ISF?
Yes, Your Honor. As indicated in the tab in the PSI, there were 2 options that were recommended, one being the state ISF substance abuse track, the other one would be an intensive outpatient track. Mr. Givens would like the court to consider giving him an opportunity at intensive outpatient. He's got a good job waiting for him. And he shows an interest in doing that.
Why didn't he, whether or not I go with intensive outpatient treatment or state ISF, why was a warrant issue? Why didn't he show up for what he was supposed to do?
I think the warrant was ultimately issued for not showing up for his sentence, but the stuff, I mean, he didn't show up. I can't address.
Why
it.
not? You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand.
I had showed up, but I was having a trial. So I went to the clerk in the back. She had wrote my name down and everything.
What clerk?
It was a lady clerk.
Yes, describe her for us.
Hispanic.
All right, that's not helpful.
Older lady, Hispanic. I don't know if I see it.
Oh, look around the courtroom. Do you see her in the courtroom? Okay.
It was, she told me what, they told me that the bond that I got off of my bonds, it was on the, I had court on the 9th, the warrant was issued on the 5th.
All right. Were we in trial on that date with the judge, Angelini? Probably so.
No, Judge, I think there's a little confusion there. I think that was a previous issue with a court appearance, maybe even last summer. We had a court.
This is March 13th.
March 13th was the sentencing date.
All right, were we in trial on March 13th? That will solve all, that will answer all questions.
She said the warrant was issued on the 9th. I mean, I came to court on the 9th and it was issued on the 5th.
Thank you. Oh, we were not in court. You just didn't show.
That's what she had said. Bond was issued on the
Mhm.
court on the 9th.
No. All right. Is there anything else from either side?
No, Judge.
No, Your Honor, I would just ask the court to consider giving him a shot at the outset, at intensive outpatient. It'd be very apparent if Mr. Gibbons is serious about it. And he'd be able to continue his employment and make his financial obligations.
All right. This is what the court is going to do. The court is going to sentence you to 6 years in the prison, suspended and probated for 6 years. There's a $1,500 fine that will be probated. There's to be a referral to felony drug court. If felony drug court doesn't accept you, then it's to be a state ISF, substance abuse track. He's to remain in custody until transfer. There's to be regular reporting by Zoom or in person. Regular UAs, 200 hours community service restitution. Do you have any children?
Yes, ma'am.
What are their ages?
14.
All right. There'll be parenting classes with rainbows. Once that's successfully completed, then the community service hours will be deemed satisfied. There's to be restitution of $228 to Bexar County for laboratory testing. There is to be proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. We'll do field visits 1 time per month for 3 months. Of course, if you are accepted into felony drug court, then felony drug court will supervise you and they may decide to change your conditions. Felony drug court is an excellent treatment. So it would probably do you great to be in that program. You understand? All right, probation. Is there anything else he needs? Is there anything else you need from the court to be successful? All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it?
Yes.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney, okay? All right, we can go off the record. You have a child. Be a parent that child can be proud that that's my dad, okay? All right, good luck to you. Thank you, counsel. Who's here on Christopher Davis? Thank you. What is happening with this case?
I'm not sure where we left off. I know I was gonna have a visit with Mr. Davis
Okay.
a couple of weeks ago.
Hi, Mr. Davis. Each time I see you, your beard gets longer.
Yes, ma'am.
Yeah. How's your son?
He's better. He got discharged last Wednesday or Thursday.
Okay.
So he's got some home health stuff going on, but he was in there for a better part of a week, so I didn't really have time to schedule my thing with Mr. Davis. I requested a visit with him tomorrow. And I'm waiting to hear back from the folks over there at the jail.
Okay. All right. And state, were you able to tender an offer?
Yes,
Do you know that all the discovery you have has been uploaded and available?
it's available.
She, the last time we were here, I had brought her an external hard drive and she gave me a hard drive with materials on it that I'm gonna go over with Mr. Davis.
All right, Ms. Ferguson, can I have a 3-week reset on Mr. Davis? And that will be your plea deadline date, okay? Is that enough time, counsel?
I think so.
All right, we'll be back on June 22nd.
Okay.
Thank you. Who's here on Isaiah Ibarra? All right, are you all ready to proceed?
Yes, we are.
Did you confer with probation?
Yes, I did.
All right, court is calling 2020 CR 12333, State of Texas versus Isaiah Ibarra. Could I have parties announced for the record for the state? Defense.
Alfredo Ortiz for the defendant, Isaiah David Ibarra, Your Honor.
Are you Mr. Ibarra?
Yes.
All right, I'm showing you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes.
Are you the same Isaiah David Ibarra who was placed on deferred adjudication in 2020 CR 12333 for the offense of robbery on April 7, 2021 for a period of 8 years? Is that you?
Yes.
All right, state.
Violated condition number 24, on or about the 6th day of October 2022 in Bexar County, Texas. The defendant, Isaiah David Ibarra, was discharged from the Center for Healthcare Services Genesis program for non-attendance in violation of condition number 24.
How do you plead to that? True or not true?
True. Your Honor, state waives all the violations.
Any objections?
No objection, Your Honor.
All right, did you understand by pleading true to violation 24, court could find it true, grant the motion, find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 24?
Yes.
All right, is there agreement?
Yes, Your Honor. It's an alternate amendment for state ISF cognitive and substance abuse treatment tracks and extend for 12 months.
Is that the agreement?
Yes, it is, Your Honor.
All right, so is he going to be able to do this? Because I see that he was supposed to be going to the Center for Healthcare Services and he hasn't been doing that. Okay, just one moment.
These agreements we participate in the classroom setting.
Okay. All right, the court will deny the motion. Alternate amend conditions to include state ISF cognitive. And then we're going to do a re-referral to the Center for Healthcare Services upon transfer. And we'll extend for 1 year. Is there anything else for me to decide?
Nothing further from the defendant.
All right. Is there anything else you need from me, Mr. Ibarra? Did you understand everything?
Yeah.
All right. Okay, thank you. Elazar Ibanez. Court is calling 2022 CR 11794, State of Texas versus Elazar Ibanez Jr. And this is an application. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Mr. Ibanez.
Are you Mr. Ibanez?
Yes, Your Honor.
Counsel, have you received all the discovery? Did you review it with your client?
I did, Your Honor.
Mr. Ibanez, I'm showing you what's entitled Application for Community Supervision. Did you review that with your attorney? Did you understand it? Did you sign it? Showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, I did, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
We are, Judge.
All right. Court will find that the court will find that the state is in compliance with discovery. Mr. Ibanez, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, I did, Your Honor.
Did you understand that you are charged with the offense of possession of a controlled substance, penalty group 1, 4 grams to 200 grams? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine.
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent? Did you understand by entering this plea, you were giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Ibanez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes, I did, Your Honor.
According to the plea, punishment is to be assessed at 5 years in the prison. There's a $500 fine. State recommends community supervision. They will take in consideration County Court Cause number 6950013. Did you understand that to be the plea?
Yes, I did, Your Honor.
Defense,
Yes, Your Honor.
state?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? And did you sign it in both places?
Yes, I did, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. State is requesting that your community supervision be for a term of 5 years. There'll be a TAP evaluation, 120 hours community service restitution, and no contact with Marriott San Antonio Northwest. Did you understand that those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence?
No objection, Your Honor.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, I did, Your Honor.
Did you understand by signing that the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony?
Sure.
And again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand? I'm sorry, just one moment. Okay. All right, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments. The court will find there's sufficient evidence to find you guilty and the court will find you guilty. Are we proceeding with sentencing?
Please,
Anything you wish to say on behalf of your client?
we ask the court to follow the plea agreement, Judge.
All right, the court will sentence you to 5 years in prison, suspended and probated to 5 years. $500 fine probated, taking consideration County Court Cause number 6950013. There's to be no contact with Marriott, 120 hours community service restitution. Do you have any children?
Yes, I did.
What are their ages?
One's 18, one's 13, and 12.
Do you have any contact with them?
Yes.
All right. Is Child Protective Services involved? All right, 120 hours community service restitution. He's to complete parenting classes with Rainbows. Once that's successfully completed, then the community service hours will be deemed satisfied. Proof of employment within 30 days. No employment as a home health care provider with minors. CAP evaluation in custody. And follow all TAP recommendations. There's to be regular reporting by Zoom or in person. The UA hotline upon release. referral to felony drug court. And I'm gonna want field visits. One time every 3 months. Upon release. Probation, is there anything else he needs? Is there anything else you need from the court to be successful? Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? Did you sign it? Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, I do.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, I do.
All right, good luck to you.
Thank
you, counsel.
Question for my client's benefit, if the referral to drug court suggests that he's a good candidate, is he required to participate or is that his choice?
Oh, no, that's not your choice. I've given you my conditions. If you don't want to participate, then that tells me you wish to go to prison. Do you understand?
I do.
Well,
Mhm.
apparently I don't understand, Judge.
Oh, if he does not, if he's accepted into felony drug court and he decides not to go to felony drug court, then a warrant will be issued for his arrest.
That answers
If
the
he is
question.
accepted into, if TAP evaluation says he needs inpatient treatment and he doesn't go to inpatient treatment, a warrant is going to be issued for his arrest because a motion to revoke is going to file. Now, if you do not want to do inpatient treatment, you can save everybody some time right now, and I will sentence you to the time in prison right now.
She's not suggesting anything of the sort. I'm
Yeah.
just trying to get questions answered so I can properly advise him when the time arrives. He's
All
not
right.
trying to offend the court. Apparently, I'm very good at it.
Yeah, no, I'm not, the court is not offended. But if people don't want to follow the conditions, then that's your option. Okay, do you understand? Do you have any questions about anything? All right, thank you. All right, everyone, I'm gonna take a 5-minute break. Yes. All right, Deputy Laura, I love my mom so much. She just called and you know what she said? You need more than a 5-minute break. So we're going to finish up these and then we're done for today. All right, so Roberto Gonzalez, that's off docket. What's,
Yes. Yeah, I'm gonna, oh, sorry.
what is this about? That's off docket.
She just left.
All righty.
Tuesday or Monday or Tuesday, she wants to give you a call for Thursday.
No. I mean, the date is the date. And St. John Smith, that's off docket too. Okay. All right, who is here on Robert Roth? Dimitri Jackson. All right, the court is calling 2023 CR 0684, State of Texas versus Dimitri Deshaun Jackson. Can I have parties announced for the record for the state?
Travis, thanks for the state of Texas.
Defense.
Largo Garza for the defendant.
All right, you entered a plea on April 19th of no contest, and you applied for probation, and you entered a plea on the offense of assault, family choking, strangulation. Punishments be assessed at a cap of 7 years. The state opposes your application. Have both parties had a chance to review the PSI report? State? Defense?
I have, Your Honor.
All right. State, do you have any witnesses?
State has no witnesses.
Defense, any witnesses?
Just my client, Your Honor.
All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, state your name for the record.
Dimitri Jackson.
All right, you can lower your hand. Defense?
Can you please state your name for the record?
Dimitri Jackson.
Dimitri, you've applied for probation in this case, is that correct?
Yes, sir.
Okay. Can you tell the court why you think you should be getting probation?
I'm very deserving of a second chance, and I want to be more helpful to my kids. While it helped me stay more focused while I'm trying to rebuild what I lost for my kids.
Okay, this was an incident that occurred and I believe you told me it was purely an accident, correct?
Yes, sir.
Did you have any relationship with this woman?
No, sir.
Wait a minute, I'm sorry.
Okay.
How's an, I mean, he's pled to assault choking, is that correct?
That's correct. Your Honor.
I don't understand how assault choking is accidental.
Oh, you talking to me?
Yes, I mean, because
Oh,
you're
sorry.
saying it was an
Oh.
accident. I don't know how you choke someone accidentally.
Oh, no, it was a misunderstanding. I mean, it was a misunderstanding.
How is choking someone a misunderstanding? And mind you, I'm just trying to figure out what you're trying to tell me.
Yes, ma'am.
So I don't understand how choking someone is an accident or how choking someone is a misunderstanding. Now, if somebody said, choke me, and you thought you heard them say choke me, and then you proceed to choke them, I can understand, oh, that's a misunderstanding. I thought you were telling me to choke you, but you didn't. So I'm trying to figure out where you're coming from.
You're referring to the whole incident, is that correct?
Yes, ma'am.
You're referring to the incident, correct?
Yes, ma'am.
And did you have any kind of relationship with this woman?
No, I didn't.
Okay. How did this come about? Did she feel that she had a relationship with you or what? Can you explain that to the court?
We was working on a business plan, and I guess our feelings got more in tune. She was trying to be more than what I was faced, not that more. So
I'm sorry, I can't understand what you're saying.
I said, we was working on a business plan, a business deal, and I guess her feelings got more involved in. She was trying to carry on a relationship, you know, a business relationship with her. So, I mean, I feel like she was posting her son, like, I mean, I
And if the court puts you on probation, how do you think this will help you and help your family?
It allowed me to rebuild what was taken away from me, what was like literally robbed from me, so. You know. It's the steps I have to take, I mean, for me to be out here with my kids. I mean, I'll do whatever I have to take. I mean, I promise my kids that I will give them the remainder of my years. I mean, rebuild attention to them than what I've given them in the past.
No further questions.
So you said that this was all a misunderstanding, and I was reading in the PSI that you also said she did it to herself. Did you recall telling the PSI person that she did the choking to herself?
Yes, I didn't touch it. I mean,
Okay, so it's your position that she choked herself.
yes.
Okay, and you told the TAP evaluation officer that you smoke 8 blunts on a daily basis. Do you recall telling them that?
I used to.
Do you still smoke 8 blunts on a daily basis?
No, sir.
Okay. And do you think you have a drug problem or need drug treatment?
No, sir.
Okay. And have you been on probation before?
Yes, sir.
Have you always completed your probation successfully?
Yes, sir.
Okay, so you've never had to have your probation extended?
I was on probation one time, I don't think so.
You've only been on probation once?
Yeah.
So were you put on probation in 1995 for assault bodily injury?
No, sir.
No?
No, sir.
So if the PSI says that you were, is that correct or incorrect?
Incorrect.
Okay, and you weren't put on probation in 2004 for possession of controlled substance, PG 1 to 4 grams? So if the PSI says that, the PSI is 1.
Yes, sir.
Okay, and you weren't put on probation for driving while your license was suspended in 2000?
Yes.
That was the time you were on probation?
No, it's in 1994.
Okay. So the 2000 for.
I was on parole. I was in prison for parole. I was on parole.
Which year did you go to prison?
2006.
But before that, no probation?
No probation.
Okay. So you were never revoked from probation before that? Okay. No further questions.
All right, any follow-up question?
No, Your Honor. Rest.
All right, the court will hear argument. State.
Your Honor, I think according to the PSI, he has been on probation many times. He's been revoked from probation many times. I think he's come to the court and he's misrepresented his criminal history. Furthermore, he's minimizing his guilt. He says that he didn't do it. He says it's a misunderstanding. He even told the PSI officer that she choked herself and that any injuries she might have had, she caused to herself. I will also point out that to the extent that defense tries to argue he had a rough upbringing, he told the PSI officer that his childhood was blessed and that he doesn't need any kind of drug treatment. He also said he doesn't see how probation is going to help him, but he'll try. I think this is someone who doesn't want probation, doesn't want the kinds of services that are available to help improve somebody's life while they're on probation. And for that reason, the state is asking that you meet the cap at 7 years.
All right, defense.
Yeah. No, you can't.
All right, if he wants to say something, I'm fine with him saying something.
Don't say so, go ahead.
When he was saying about it wouldn't help me. I was talking about the treatment, the classes, not as for the probation. The lady had called me again yesterday from the PSI, letting me know that she was typing too fast and some of the words got mixed up. And she called me again yesterday and was asking me more questions. Because when I did my PSI, she really wasn't understanding what I was saying. Before it's what she typed on the paper.
Okay. All right, defense.
Well, Your Honor, I think this case has been going on for quite a while. He hasn't been in any further trouble, Your Honor. I think this was an incident that occurred because I think the lady thought that she had a relationship with him and he did not want to.
we're asking the court to put him on probation. I believe he knows that probation will help him. He'd like to do what he can to get a job, do what he can for his family and be there for his family. So we're asking the court to place him on probation.
All right. Mr. Jackson, I want you to know, I did look at everything. I just don't think that you're a good candidate for probation. What I'm going to do is find you guilty, and the previous judge found you guilty. Going to sentence you to $500 fine, time and money, run concurrent. There's an affirmative finding of family violence. There's to be no contact with Elizabeth Dahl. Take in consideration 2020 CR 2357, and I'll sentence you to 6 years in the prison. Give you credit for any time served. All right. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it? All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, Mr. Jackson, if you want, I can ask that you be referred to the therapeutic community. It does not increase the length of time that you're in custody, but it may be able to help you with any drug issues you may have. Do you understand? Would you like that or no?
Yes, I was trying to understand because
All right, thank you. Good luck to you. Norma, on Pedro Alvarez, when do you want to call that back? Because it's a PTD.
Sometimes if you again,
All right, June 12th. All right, who's here? Robert Roth. And I'm sorry, are you Mr.? You can call him up, Norma. And Roth, if you'll come down. Mr. Alvarez, did you fill out your paperwork for PTD?
That's a little bit, yes. We got the approval on it.
Oh, then Norma, do you still want to keep it on the 12th, or you want to just? Okay. All right. Robert Joseph Roth.
Yes, ma'am.
Roth.
How you doing, Honor?
All right, how are you doing today?
Great.
All right, this is no application. Court is calling 2000.
An application.
It says no application on here.
Believe it, what, it's set for a PSI on an application.
Okay, I don't, let me look through the file. I think maybe there was a mistake on the docket sheet by someone else. Let me just check. Okay. All right, you entered a plea of no contest on April 17th, 2023. Can I have parties announced for the record in cause number 2023 CR 3458W, State of Texas versus Robert Roth?
Daniel Escobar from the state of Texas.
And James Merritt for defendant Robert Roth.
All right, are you Mr. Roth?
Yes, Your Honor.
Roth?
Raw.
Roth,
Yes.
okay.
Thank you.
You entered a plea to evading arrest, detention with a vehicle. According to the plea bargain agreement, punishment is to be assessed at 4 years in the prison, and the state is opposing your application. Did you have a chance to review the PSI report with your attorney?
Yes, I did, Your Honor.
All right, state, any objection to the PSI report?
No, Your Honor.
Defense, any objection to the PSI report? All right, the state is opposed. Does anyone have any witnesses? State?
State doesn't have any witnesses.
Defense?
No witnesses.
All right, then the court will hear argument.
Judge, the facts of this case are very concerning. He was speeding in a neighborhood. BCSO attempted to pull him over. After a very short chase, the defendant did wreck out, going at a very high excessive speed. He was driving a motorcycle. That's how BCSO was able to apprehend him. I will point out that the defendant does have a prior felony case where he did get 3 years for adjudication. That was back in 1998. That probation was revoked. And then, other than that, he has recent felony history that's coming out of Wilson County, just unlawful possession of firearm by a body.
All right, defense?
After reading the PSI, it appears that the PSI leans towards, if probation is granted by this court, that the PSI leans toward a inpatient treatment at a SATA facility. And I think it leaned towards that on the belief that it found that Mr. Roth was not acknowledged that he has a drug problem. I think Mr. Roth would like to make one statement to the court that he does acknowledge that he does struggle with drug dependency problems. He is taking steps before being arrested, before being in custody. He was taking steps to acknowledge, to take care of those problems of drug dependency. He was hoping to continue his progress on an outpatient basis. But likewise, he's listened to many PSIs that's come before the court this afternoon, and he would be he would like to engage as well in a drug court program if the court thinks that would be a better solution for this period. We asked the court to, he does have stable housing, stable employment.
All right, so was this motorcycle stolen that he wrecked? Because that's what I'm reading in the police report.
At that point in time, ma'am, I did not know that bike was wrecked. I was working at a job in Rockdale.
All right, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. What were you saying?
I was saying that at that point in time, I was working in it. Me and my brother, he had purchased a bike from somebody else and he wanted a different bike. So we did a trade out on work. I've been running that bin and everything on that bike and it never came up stolen. So that's why.
Why would you run a bin on a bicycle?
On a motorcycle. That way I was to make sure it wasn't a stolen motorcycle.
Why were you speeding? And why didn't you pull over when the police were trying to stop you?
That was just a stupid error on my part. That's just wasn't thinking straight with my mind in life right there. That's a mistake. And I was like I said, yes, I'm very much sorry for taking up the time in report for this mistake of mine.
Oh, you're not taking up the court's time. I mean, this is what we're here for.
Still, I feel ashamed.
Counsel, this is yours. You want to come around? Sure.
That's poor judgment on my behalf. I apologize for that.
How old are you?
I'm 50. I just turned 50 years old last week.
Okay.
Judge,
Yes.
one quick opportunity. At the time of this case, the evading, you had another pending case, is that correct?
Yes.
And isn't it true that you failed to appear at that other court?
I was sick on that, and I tried, and that's what I went over that one time. I was very sick, and I tried to contact the court and the prosecutor's office throughout the court system that whole day long, leaving messages to for y'all to get actually ask for a Zoom on that day to get a reset. And that's the honest God truth, bro.
Nothing further.
All right, this is what the court is going to do. The court is going to deny your application, find you guilty, sentence you to 4 years in the prison, give you credit for any time served. There's a $300 fine. Time and money will run concurrent. Take in consideration night mag number 6999327, 2022 CR 10345A. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? If you would like, because it does say that there are some drug issues, I can recommend the therapeutic community for you. It will not increase the time that you are serving your sentence. If you would like, I could do that. Okay. All right. Thank you. Good luck to you. All right. Is there anyone else in the box, Norma? Who is here for Ortiz?
Was Anthony Control?
Well, we're going to have to put that on another day. All right, Ms. Ferguson, can we recall Ortiz for a different day? Can we put this, what date do you recommend? All right, so we'll recall it back on Monday. And that's the 5th. All right, anyone else?
Oh, no, nobody else, but we just have that.
Okay, if you can bring that person out. And we are done for today, and I don't think we have anything. Do we have anything on the docket on Friday? We do not. I don't think we do.
Judge.
Wait, we do? What?
No, there was a.
So everybody that's up, they send back, send over on Monday.
Yes. And I'll go over the files with you all on that.